No, even in this petition that she has not contested. In the but in the writ petition also, No.
Members, Lordship. Lordship, I think you mentioned item number 24, hearing, Lordship, part 2. Lordship, on the last occasion, I was given a direction to obtain instruction, Lordship, with regard to the revised rate of the entitlement of pregnant women under JSSK scheme. Lordship, I've got some information, but I have not got all the information as of date, Lordship. So if 2 weeks may be granted to me, Lordship. I've taken the permission of the council for the petition also.
You are there?
2 weeks.
On the prayer of Mr. N. Mosley, Learned Counsel for respondent number 4.
Lordship.
Further 2 weeks' time is granted for obtaining instructions in terms
Lordship.
of the last court's order.
Lordship. Oblige, Lordship.
May I please, Lordship?
Yes.
My Lord, I beg to mention item number 25 and 26. My Lord, in 26, I'm yet to file affidavit. So I'm yet to receive instruction. Kindly allow me 3 weeks' time. my lord.
Why is it connected together? 25 is writ appeal.
Yes, yes.
26 is writ petition.
Writ petition, yes.
How come it's connect? How come it's?
My Lord, in the writ petition, this petitioner is the respondent in the writ appeal.
Okay.
So,
You want to file affidavit in the writ appeal and writ petition.
the writ petition.
Any objection? Okay. On the prayer of Mr.
E. Popom,
E. Tivapom, Learned Counsel for the
statement.
state respondents in WPC number 296 of 2023 are not objected to by the other side. How much time?
3 weeks' time.
3 weeks' time is granted for filing counter affidavit. List the matter again after 3 weeks.
And my Lord, I beg to mention item number 14. Here, my Lord, affidavit is ready. I'm going to file today. So let the matter be come up next week, my Lord.
Yes.
Next week, Lordship.
All right.
Next Wednesday.
Mr. E. Tivapom, Learned State Council submits that counter affidavit will be filed during the course of the week. And therefore the matter may be posted again after a week. The prayer is not objected to by Learned Counsel for the opposite party. Next para in view of above, list again after a week.
My Lord, similar prayer for item number 18, my Lord.
Similar order?
Item number 18.
Similar order will do?
Lordship, I'm for the petitioner, and there's been some subsequent development here.
Hmm.
My extension has been my detention, Lordship, has been further extended,
Hmm.
and therefore I wish to incorporate that in my petition as well. Therefore, I kindly permit me to file one IA, Lordship, in that regard to incorporate the late.
Surely you may file if you want.
I beg your pardon,
You can file.
Lordship.
How much time do you require for that?
A week's time will suffice.
All right.
Next week. my Lord.
List the matter again after a week. Petitioner is permitted to file IA to incorporate the latest development. Similarly, government advocate is permitted to file counter affidavit in the meantime.
Yes.
All right?
Much obliged.
May I please, Lordship?
Yes.
Lordship, item number 19 and 20, Your Lordship.
Ah.
I am for the appellant. Today, I have some personal difficulties, Your Lordship. I have already filed my adjournment prayer slip also, Your Lordship. If the matter will be taken up on 14th, Your Lordship, next Wednesday. Today, I have some personal difficulties, Your Lordship.
Who's for the other side?
19, 20,
Lordship, I'm for the state.
Hmm?
I'm for the state.
next Wednesday.
Any
Your Lordship.
objection?
No.
On the prayer of Mr. T.B. Jamil, learned counsel for the petitioner and not objected to by the other side. Matter be listed again on 14th of
14th.
February.
March.
Please, Lordship, Lordship, I beg to mention item 11. Lordship, here, in this case, AG is leading the matter. So I pray that the matter may be fixed on 28th of February, Your Lordship.
Item 11.
Yes.
Ms. V. Shukre, learned. Any objection?
No.
Ms.
On
V.
20th,
Shukre.
Lordship,
Sorry,
is it being fixed on 28th?
28.
Yes, 28.
Ms. V. Shukre, learned additional AG, submits that she is led by the learned advocate general in the matter. And since he has some, the matter may be adjourned.
On that day, I have the difficulties. I have a fixed pattern now for one trial, 28.
So come to a consensus, which date do you want?
Before that,
And therefore the matter may be listed
before that also.
on a convenient date.
Then-
Next para, in view of above and as paid for by the parties, list the matter again on when?
For me, no problem.
Lordship, my request is that let this matter be adjourned for a while so that I intimated AG to get his
Okay.
fixed date. Lordship,
Keep it blank. You inform the date to her.
Lordship,
Yes.
Lordship.
Right.
May I please, Lord.
Yes,
My lord, I beg to mention item 12.
yes.
Let this matter be listed next Wednesday, my lord. Next Wednesday, coming Wednesday.
All right. As paid for by Mr. Azo, learned counsel for the petitioner, list the matter again on next Wednesday.
Yes, there is an interim, my lord. Let this
Interim order passed earlier shall continue till the next date.
Much.
Yes.
May it please, my lord,
Hmm.
I may be allowed to make a mention for item 9, Lordship.
Nice.
If it can kindly be listed next Wednesday.
Why,
My lord,
I am to file an affidavit and the client still be coming this Saturday.
what affidavit?
this is PIL. I am for the respondent.
Hmm.
This is 2020 matters. So if it is adjourned, then it is be a fixed matter on Wednesday.
My lord.
What affidavit do you want to file?
I want to reply to the affidavit, the latest affidavit that the private respondent has filed, the respondent number 7.
My lord, on 11th October last year, there is short time to file affidavit. This is 3 months now. Even within 3 months, they couldn't file affidavit.
Lordship, the affidavit is ready. They'll be coming on Saturday.
Okay.
I've been informed. They are living in area bordering Burma, Lordship.
Okay.
So it's quite far.
So when? Wednesday?
Yes,
Wednesday is a
coming
fixed
Wednesday.
item, my lord.
Mr. Sentianger, learned counsel for the petitioner submits that may be given a week's time to file the rejoinder affidavit to the affidavit of the respondent, number 7.
7, my lord.
So the prayer is not objected to by the other side, subject to the matter being listed again on Wednesday next.
Wednesday, my lord, on that day, if
in-
it is in this as item 1,
In view of above, it's all right. Any item, I don't think it's a very lengthy list. List the matter again on Wednesday next, huh? Give the date.
Deeply obliged.
Much obliged.
Yes.
Please, Lordship, I beg to mention item number 10. I may be given, for the respondents, I may be given 2 weeks' time to file the objection to the affidavit filed by the petitioners, the additional affidavit.
You are for which respondent?
Respondent 1, 2, and 3.
Or what do you want to file?
Objection to their additional affidavit.
Objection. The petitioner has filed additional affidavit.
Yes, Lordship.
I see.
Yes, Lordship.
What is the matter about?
Yeah, this is a criminal contempt, Lordship. We have filed this criminal contempt due to the respondents have made some false statements before this honorable court,
All right,
Lordship.
all right. So how much time do you require?
3 weeks time may be given, Lordship.
Why 3 weeks time? All right. On the prayer of learned counsel for the respondent,
1 to 3.
numbers 1 to 3. For 3 weeks time is granted for filing objection to the additional affidavit filed by the petitioners. List again after 3 weeks.
Lordship.
I mean, so-
Lordship,
Yes,
Lordship, item number 7, on behalf of Mr. YB Gupta. May I come back after 2 weeks?
yes, who is YP Gupta?
The situation, from the Union of India. Union of India, yes.
Milord, I'm appearing for in item 7, Milord.
Yes, YP Gupta is for which respondent?
For the Union of India, gimana saya? Union of India. 8, item, respondent 8.
He's a CGC.
Yes, my lord.
You want adjournment on his behalf?
Yes, Lordship. He has still to file his affidavit. He has not filed his affidavit so far.
What affidavit? This is a writ appeal.
That was the instruction, Lordship.
No, do you file affidavits in writ appeal? Others normally don't file. Whatever was decided before the single judge is again put before the division bench and it is looked into. Of course, in there might be instances where you have to file additional affidavit or something like that. But unless that requirement is there, you want 3 weeks time for this. Okay,
I am appearing for the appellants, Milord, in this matter.
okay. You are, madam, your name?
Pinky Anand, Milord, senior advocate.
Okay, Pinky Anand.
Uh, my only grievance is, Milords, I would have pressed for the stay, Milords, in the meantime, while the union files, Milords, their documents, Milords, and the counter affidavit. Milords, in the present case, this is a constitutional right that has been exercised by the central government as well as, Milords, the state government in accordance, Milords. So, Milords, in the meantime, the notification of the state government and the circular has been stayed, Milords. So, Milords, rather the notification of the state government, Milords. So, if your lordship could, Milords, consider, Milords, staying in the meantime, Milords, pending the of the matter, seeing the order of the learned single judge, Milords.
I'm for the respondent number 1, 2, and 3. I'm the petitioners before the learned single bench. And your lordship may appreciate that the impugn notification was stayed by the learned single bench.
Okay.
So the question of staying here, the learned single bench judgment will not arise in this case.
Impugn notification was stayed.
Stayed.
And
before the learned
ultimately it
single
was set aside by the
bench. Yes,
single
ultimately.
bench.
And then we have challenged this.
Milords, in this case, Milords, just very briefly, Milords, as far as the petitioners are concerned, the writ petitioners, Milords, they are in fact, Milords, unauthorized and illegal operators at best, Milords, whatever their case may be, Milords. They've come forth to this honorable court in that capacity. These notification, Milords, of the state government has been issued, Milords, pursuant, Milords, to the Act, the Food Safety Act, Milords, the Prevention of Cruelty to Animals, and the Slaughterhouse Rules, Milords. In each of these provisions, Milords, this is considered, the dog meat is considered as not food, Milords, and therefore, Milords, it is impermissible to kill animals for that purpose, which is the purpose in question, Milords. This, Milords, comes under the purview of the Acts, Milords, as mentioned, as well as, Milords, Article 256 of the Constitution of India, which mandates that I must follow directions. Now, Milords, what is happening is unauthorized illegal operators, Milords, in any case, who have no locus, Milords, to be before the court, challenge, and Milords, there are some judgments of this honorable court only, Milords, of your lordships, Milords, which in conjunctive benches, Milords, which ultimately have held, Milords, that in such circumstances, Milords, there is legitimacy. But in any case, Milords, I will reserve the rights to argue the entire matter, Milords.
Madam, we'll have a proper hearing.
Very well.
Once the parties are ready, we'll have a proper hearing.
Your Lordship had directed early hearings, so very well, my lords. I was only saying that in the meantime, my lords, these actions tend to, my lords, ultimately, my lords, endanger. That's one of the issues, my lords, in question.
But without any proper hearing, if your lordship stays the EP judgment, then much prejudice will be caused to the respondent number 1, 2, and 3.
No, that's why you come to a consensus. When can the matter be?
It can be disposed of in one
heard
hearing
and
if my
disposed of.
learned senior court has no objection, instead of going for a stay hearing.
So, my lords, subject to your Lordship's calendar, my lords, and facility, my lords, they're asking for some time, my lords, maybe 11th of March, my lords.
Mr. Gupta wants some time.
Yes, my lords, that would give them about a month, my lords.
It has to be.
But may I ask, is there any requirement of filing affidavit in this case?
That is.
For the learned single judge, the union, they filed the affidavit.
Affidavits have been
And
exchanged
in the
before the
appeal- in
single
the
judge.
appeal memo, no new documents. have
So
been
no
addressed, so
no
there's
further
requirement.
affidavits
Yes,
required,
yes.
isn't it? So which date is convenient for the parties?
My lords, subject to your Lordship's calendar, my lords, 11th of March, my lords.
Your Lordship, only on Wednesday, we have a division bench here.
No, 11th of March is Monday.
So, my lords, could it be
13th
13th?
of March. 13th of March.
Very well.
All
So
right.
that last four is 14th.
Inconvenience has been expressed on behalf of Mr. YP Gupta, Lanet CGC, who appears for respondent number 8. Stop. On the prayer made on his behalf and as agreed to by the parties, that the matter be posted again on 13th of March 2024 for admission.
My lords, for disposal, if your Lordship would post it so that, my lords, hopefully that can be, my lords, taken care of.
An attempt shall be made to dispose of the matter on the next court date. All right.
And also, my lords, one last request, my lords, some other respondents have not filed. If they want to file, my lords, let them do so and be done with the exercise.
Oh, no, file what?
My lords, if they want to file any response, my lords, there are at least 2 other respondents who don't seem to have filed, so, my lords.
I don't think it's required.
I'm grateful, my lords. I agree with that. I'm sorry.
All right.
Please, your Lordships.
Yes.
I'd like to mention item number 27.
Yes.
Your Lordship, my seniors in bereavement,
Mm.
we have submitted our adjournment slip yesterday. So the matter could kindly be fixed on March 6th.
6th of March.
6th.
Okay. Is it agreeable to parties? Who's in bereavement? Mr. Zimomi?
Yes, sir.
Mr. A. Zimomi, learned counsel for the petitioner, for the appellant, is reported to be in bereavement. Stop on a mention made on his behalf and not objected to by the other side. Let the matter be listed again on 6th of March 2024 as paid for.
That's good.
Lordship,
Yes.
Lordship, I want to mention item number 16. Lordship, I have received the affidavit filed by the state, and I've received a copy this morning. So I have to go through the contents. Lordship, may kindly grant me 1 week time.
Counsel for the petitioner submits that she has just received a copy of the counter affidavit, and therefore she may be given a week's time to go through the same and file a rejoinder if so advised. Prayers allowed. This is the matter again after a week. Item 16, isn't it?
Yes, sir.
All right.
Much obliged.
Yeah, please, Lordship.
Yes.
Lordship, I beg to mention item number 2 and 3, Lordship, in the motion, please, Lordship.
2 and 3.
Yes, Lordship.
Yes.
Lordship, the leading counsel is out of station, Your Lordship. So I pray that this matter may be passed over for next week, Your Lordship.
We'll see. Let the matter be called out. If notice is to be issued, we'll issue, isn't it? All right. You be here.
Okay. Bless you.
Mr. Lordships, I beg to mention item number 22. Lordship. Yeah, service report on respondent number 6 and 7, Lordship, is still awaited, Lordship. So if I may be allowed to take dusty service, Lordship.
Ms. Luciano, learned counsel for the appellant, submits that neither ID card nor unserved notice has returned back from respondent numbers
6 and 7.
6 and 7, and therefore she may be permitted to serve notice to them by way of dusty.
Yes, Lordship.
The prayer is allowed. Stop. Let respondent number 6 and 7 be served through dusty. to the registry of this court within a period of
2 weeks. Lordship.
2 weeks from today, and the petitioner shall thereafter file an affidavit as proof of service to the said respondents. List the matter again after 3 weeks.
Much obliged.
For motion, item number 1.
Thank you, Sir Lordship. Lordship, here I have instruction to withdraw the appeal, Your Lordship.
Any objection? Any objection? No objection. Ms. V. Shukre, learned additional AG, submits that she has instructions to withdraw the appeal. Mr. L. Iraru, learned counsel for the private respondents, has no objection to the prayer. Next, para in view of above, the appeal stands dismissed as withdrawn. Next, in the IA, in view of the order passed in the writ appeal, the IA also stands dismissed as withdrawn. All right.
For motion, item number 2.
Yes, who was seeking adjournment? You were seeking adjournment.
The leading counsel for the appellant is from Dimapur, Your Lordship. So he's out of station. So he's requesting for this matter to be passed over till next week, Your Lordship.
Pass over till when?
Next week, Your Lordship.
Next week.
Yes, Lordship.
What is his name, leading counsel?
Ali.
I didn't know my.
Yes, Lordship.
Okay. Okay, then on the request made on behalf of the learned counsel for the appellant, stroke applicant, Mr. K.A. Rome, matter stands adjourned for a week.
Obliged, Lord. Same, Your Lordship. Item number
Okay, item 3 also, similar order.
For motion, item number 4.
Please, Lordship,
Yes.
the appellant in this case is Your Lordship, Nagaland Lokarta. And the appellant is angry by judgment order dated 15/1/2024, caused by the learned single judge in writ petition number 8 of 2023, Your Lordship. Now, Your Lordship, the issue involving the present appeal, Your Lordship, it relates to the jurisdiction and power of the Nagaland Lokarta as per the Nagaland Lokarta Act of 2017, Your Lordship. Now, therefore, Your Lordship, before I take Your Lordship to the impugned judgment and order, I may be allowed to refer to the relevant provision relating to the jurisdiction and power of the Nagaland Lokarta as per the Act. That is the Nagaland Lokarta Act 2017, Your Lordship. In fact, Your Lordship, similar provision as in the provision in Nagaland Lokarta Act are also similar to the Lokarta Act in other states, Your Lordship. Now, as per the Act, Your Lordship, the Act envisages, Your Lordship, two types of complaint. One is complaint involving grievance, and the second is complaint involving allegation, Your Lordship. And the Act also provides for limitation period. May I take your lordship to section 9(3). Section 9(3). Lordship has got it?
Yes.
I have also highlighted. The Lokata or Upalokata shall not investigate any complaint involving a grievance, Lordship, made after expiry of period of 12 months. That is the limitation period. So far as grievance is concerned. Second, your lordship, B, any complaint involving an allegation. There is complaint involving an allegation. For that limitation period is 5 years, your lordship. Like provided that Lokata, some discretion is given, may entertain a complaint made after expiry of the said period if the complainant shows sufficient cause for not making the complaint within the said period, your lordship. Now, in the Act, your lordship, the word allegation is not defined. However, for the purpose of the issue involved in this present appeal, your lordship, we are concerned with the word grievance, and which is defined in section 2G, your lordship. F is the complaint. G, lordship has got it?
Yes.
May I read out? Grievance means a claim by a person that he suffered injustice or hardship as a consequence of maladministration, your lordship. Now, in my respectful submission, your lordship, the word grievance as used in the Act must be interpreted and construed strictly in consonance with the definition as provided in section 2G. The word grievance, it cannot be given a wider interpretation and thereby defeating the very purpose of defining that word grievance in section 2G, your lordship. Therefore, your lordship, a complaint involving grievance can mean and only mean, your lordship, those complaints relating to injustice or hardship suffered by the complainant himself or herself, your lordship, going by the definition. And this is further clarified, your lordship, if my lordship may kindly see section 10(1). 10(1), your lordship.
Yes.
My lord has got it. Subject to the provision of this Act, a complaint may be made under this Act to the Lokata in the case of an allegation by any person, and in the case of grievance by a person aggrieved, your lordship. Provided that where the person aggrieved is dead or is for any reason unable to act for himself, the complaint may be made or continued by his legal representative or by any other person who is authorized by him in writing in this behalf. So, your lordship, in my humble submission, from a bare reading of section 2G, read with section 10(1), it is absolutely clear that a complaint against another person will not come within the ambit of a complaint involving grievance, your lordship. Your grievance, complaint involving grievance must relate to the injustice or hardship suffered by the complainant himself or herself, your lordship. Now, coming to the jurisdiction, your lordship, may I take your lordship to section 35. Section 35, it provides that the provision of the Anti-Corruption, Grievance, Redressal and Whistleblowers Protection Act shall apply mutatis mutandis to the state of Nagaland. So, for a moment, may I take your lordship to the Whistleblowers Act, which I have furnished your lordship. The Whistleblowers Act, Whistleblowers Protection Act, 2011. Now it is 2014, your lordship. I'll take your lordship to the definition, section 3C, your lordship. Lordship has got it. Three C, your lordship.
Yes, complaint.
3C is the
Complainant.
complainant. Complainant means any person who makes a complaint relating to disclosure under this act. Complaint relating to disclosure, your lordship. And D defines the word disclosure. Disclosure means a complaint relating to an attempt to commit commission offense under PC Act. Number 2, willful misuse of power or willful misuse of discretion by virtue of which demonstrable loss is caused to the government, or demonstrable wrongful gain accrues to the public servant or to any third party. And 3, attempt to commit or commission of a criminal offense by a public servant made in writing or by electronic mail or electronic mail message against the public servant, and includes public interest disclosure referred to in such and such, your lordship. So, your lordship, broadly, apart from having jurisdiction and power to investigate complaint involving grievance and complaint involving allegation, your lordship, the Nagaland Lokarta can also investigate complaint relating to disclosure under the Whistleblowers Protection Act, your lordship. Now, your lordship, the act also provides for matter which cannot be investigated by Lokarta, your lordship. On bar, there's a bar. For that, may I take your lordship to section 9 of the act, Lokarta Act, your lordship. Section 9(1), your lordship. For the purpose of this appeal, lordship has got it?
Yes.
May I read out? Except as hereinafter provided, the Lokarta or Upa Lokarta shall not conduct any investigation under this act in the case of a complaint involving a grievance, your lordship. This is very important, your lordship, because there are 3 types of complaint: complaint involving grievance, complaint involving allegation, and complaint relating to disclosure under the Whistleblowers Protection Act, your lordship. There are 3 types of complaint which can be investigated by Lokarta. And your lordship, here, section 9(1) specifically mentions about complaint involving a grievance in respect of any action, A, if such action relates to any matter specified in the second schedule, or B, if the complainant or any other, your lordship, we are concerned with A, your lordship, this appeal. So may I take your lordship to the second schedule? That will be the last page, your lordship. Lordship has got it?
Yes.
So second schedule, this is number A, action taken for the purpose of investigating crime, we are not concerned with this. B, action taken in excess of power in relation to determining a matter shall go to the court or not, we are not concerned with this. We are not concerned with C. Here we are concerned with D, your lordship. Any action taken in respect of appointment, removal, pay, discipline, superannuation, the subject matter is superannuation, the complaint, or other matter relating to condition of service of public servant, but not including action relating to claim of pension, gratuity, provident fund, such, your lordship. Now, in my respectful submission, your lordship, from a bare reading of section 9(1)(a), read with clause D to the second schedule, your lordship, what is barred is complaint involving grievance only. Therefore, complaint involving allegation and complaint relating to disclosure under the Whistleblowers Protection Act, your lordship, is not barred, your lordship, by section 9(1)(a), read with clause D to the second schedule, your lordship. However, in the present case, your lordship, a complaint against opposite party number 1, 2, and 3 in the present appeal, Your Worship, alleging overstay in service has been held as a complaint involving grievance by the learned single judge. Hence, Your Worship, the appellant is before this. Your Worship. So now may I take Your Lordship to the judgment and order.
May I please, Your Lordship? It appears that my learned friend is going to take a little more time. I have instructions to represent respondent number 1, 2, and 3. All of them are due for retirement on 31st of May 2024, barely 3 months left. And the issue in this case is with regard to the overstay, allegation of overstay on the basis of a complaint lodged by a person who is unknown, and the Lokayukta is not willing to disclose that who has filed the complaint. So basing on that, they have started the investigation,
preliminary
inquiry against the petitioners, state petitioners, of course. In the present appeal, we are respondents. Now, since they are due for retirement only on 31st May, 2024, just 3 months. So keeping the matter pending for a long time will adversely affect your pension and all that. And our stay in service is on the basis of the government orders. And our length of service has been counted from the date of regular appointment on 1st of June 1989. So the due date of retirement as per the government report is 31st May 2024. In 1 year in advance, the government has already notified who are retiring from service on attaining 35 years of length of service, who are retiring on attaining 60 years of age, as per the Nagaland retirement from public employment.
Mr. Jamir, what are you suggesting?
Lordship.
What are you suggesting? You'll be appearing for the
3 respondents.
They are the petitioners.
I'm the petitioner.
They were the petitioners. So your writ petition has been allowed.
Yes.
The respondent is in appeal now.
Yes.
This is the first time it's been listed, isn't it?
Lordship.
So what do you suggest? That the matter should be heard?
I would suggest that the matter should be heard next Wednesday. I may be served with a copy of the appeal memo, and then it can be disposed of at the admission stage, Lordship. Either way.
So Jamir, what do you say?
I have no objection, Your Lordship. In fact, he has heard all. It's okay. I have no objection. In fact, matter
It is like trying to
Wednesday for
dig
final
out the
disposal.
coffin from the grave. I mean, single judge has comprehensively dealt with the issue.
The issue is very simple, Your Lordship. Purely question of
arrived
law.
to the finding.
So we'll issue notice and make it listed on Wednesday then. Next
Lordship.
Wednesday. We'll receive an accept notice on behalf of the respondents.
Opposite party, 1, 2, and 3.
Government
How
is
many?
also a party, Lordship.
Government, who's there? Government? Respondent number?
The last occasion I appeared to the
Writ petition, yes.
the written, I have not received.
You'll get, don't worry, you'll be appearing for which respondent?
Actually, we have already served copy to the state. The state that was accepted notice is not here.
Next Wednesday will be a auspicious day, Lordship.
In fact, receipt is on record, Your Lordship.
No, state is not a party.
State is a party pro forma.
State is not a party.
No, it's a party, Your Lordship, pro forma.
How do you say?
And we have already served notice, Your Lordship.
Chief engineer is not a state. Chief engineer is not a state.
Yes.
Your pro forma respondent is chief engineer, Department of Water Resources.
Lordship.
He cannot be a state.
Grateful.
He's only a department.
Lordship.
State will have to be represented by a secretary of whichever rank, under secretary and above.
He is the party in the writ petition.
So Mr. Form will be for respondent number 4.
Yes.
You are basically a pro forma respondent. You are the employer or the controlling officer. Heard Mr. T.B. Jamil, learned counsel for the appellant, who submits that being aggrieved with the judgment in order dated 15/1/2024 passed by the learned single judge in WPC number 8 of 2023, allowing the writ petition, the appellant is before this court in appeal. Stop. At this stage, Mr. C.T. Jamil, learned senior counsel, assisted by Mr.
I Imchen,
appears for the respondent numbers 1, 2, and 3. And submits that since the said respondents are on the verge of retirement, the matter may be taken up for final disposal by Wednesday next. Stop. The proposal is agreed to by Mr. T.B. Jamil. Next para, in view of above, issue notice to the respondent numbers 1, 2, and 3. To the respondents, returnable by next Wednesday. Give the date. Mr. I. Imchen, learned counsel, appears and accepts notice on behalf of respondent numbers 1, 2, and 3. While Mr. E. Tivapom, learned state counsel, appears and accepts notice on behalf of respondent number 4. Appellant to serve requisite copies of the writ appeal to the learned counsels appearing for the respondents today.
Lordship.
List the matter again on Wednesday next.
Lordship. The issue is very simple, Your Lordship.
Yes.
Whether a complaint against the opposite party 1, 2, and 3 alleging overstay will come within the ambit of the complaint involving grievance.
This is the first case of its kind.
Yes.
Huh? The Lok Ayukta has entertained such kind of case for the first time.
yes.
Any other
I
case?
think,
No.
I think there are also other cases now pending.
Okay.
Yeah. And as I've said, Your Lordship,
There was some case regarding quarter
quarter
and all
allotment,
that.
yes, Your Lordship. In fact, Your
My
Lordship,
learned friend is concerned with the other cases which are yet to be heard. And this is the first case which has been decided against Lokayukta. So if this is allowed, then others will follow the suit. That's how they are before this honorable court. Otherwise, in this particular case, there is no involvement of under Prevention of Corruption Act. Therefore,
Okay.
the learned single judge has perfectly deal with the matter. Lord.
We'll hear the parties.
yes, and Your Lordship, even before the learner single judge, I have submitted that, so this matter relates to jurisdiction. So I am not going to be adversarial. Because Lokayukta, now, this is a public institution. Whatever jurisdiction is defined by the court, Lokayukta will function accordingly, Your Lordship. And similar provision, other states also has similar provision, Your Lordship. So that is the thing. I'm not going to be adversarial.
All right.
Your Lordship.
You enlighten us on next Wednesday.
Lordship, I'll do that. Highly obliged.
For motion, item number 5.
May it please your lordships. Lordship, I filed this interlocutory application with a prayer that my name may be struck off from the list of from being included as a respondent, Lordship, for the reason that I'm no longer a necessary party. The petitioner does not require any relief of me, Lordship. And Lordship, it was on the my lord.
It is not the petitioner who is asking for striking out.
Lordship.
It is you who have come step forward saying that I'm not a necessary party.
Lordship, yes.
Isn't it?
Yes, my lord.
So then we'll have to hear the other side. What is your instruction?
Lordship, we have no objection since they are not necessary party anymore.
Okay. You are for the
I'm for the petitioners.
petitioner. What about state? Any objection? Okay, we allow the striking of them. Thereafter, what happens? Sorry?
I order dated 22/11/2023.
Have you impleted?
Not yet, my lord.
Okay, you are Mr. Alezo.
Lordship.
We have perused the last court's order dated 31/1/2024. Full stop. Mr. Alezo Kiret, learned counsel for the applicants, submits that the applicants have prayed for striking out their names from the arrayed respondents in the connected with petition. Since the petitioners are not seeking any relief against them. Stop. Miss, your good name?
Kim Hombeni Izon.
P. Momeni Izung, learned counsel for the writ petitioners, and Ms. V. Shukre, learned additional AG, appearing for the state respondents. I have no objection. To the prayer made. Stop. In view of above, the respondent numbers, you just see the numbers, okay? They are all given here. 5 dash dot 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 up till 74, okay? In WPC number 123 of 2022 are allowed to be struck off. From the arrayed respondents. Stop. Registry shall do the needful. The IS stands disposed of as allowed. Then in the main writ petition, you write on the prayer of Miss So-and-so, learned counsel for the petitioners. How much time?
1 week.
A week's time is allowed. A week's time is granted for filing an application for including the central government. Which ministry?
Home Ministry.
For including the Ministry of Home, Government of India, as party respondent to the writ petition. List the matter again after a week.
For motion, item number 6.
Detail has been filed against the judgment in order dated 29/11/2023. As per the judgment, WPC number 236 of 2017. We should be filing the present appeal. It gives a delay of 40 days.
So notice will have to go.
So the private respondent number 4 and 5 has been implemented in the individual capacity. So let the notice for this.
But Mr. Lima Wapang, learned counsel for the applicant, who submits that by filing this application, the applicant prays for condoning 40 days delay in filing the connected with appeal against the judgment and order dated 29/11/2023 passed by the learned single judge in WPC number 236 of 2017. Next para, issue notice to the respondents, returnable by 4 weeks. Ms. B. Shukre, learned additional AG, accepts notice on behalf of respondent numbers 1, 2, 3, 1, 2, and 1, 2, 3,
Only 1, 2, and 3.
1, 2, and 3. Then-
Instead of respondent number 6, 7, 8, and 9, we have accepted the CGC. That can only be accepted this. Is that-
Where is the acknowledgement? Where is his acknowledgement? It's not available. Huh? Sorry? No, if you have served copy, you must have acknowledged it. Where is his acknowledgement? Applicant to serve notice to the respondent numbers 6, 7, and 8.
6, 7, and 8.
6, 7, 8, and 9
Yes, yes.
through
Z
Mr.
N only.
ZN Muli, learned CGC. Stop. Once notice is served, the applicant shall submit the acknowledgement received from the learned CGC before the registry. Next para, the applicant shall also take steps for service of notice upon the respondent numbers 4 and 5 by registered post with ADDU within 3 days. List the matter again after 4 weeks. Respondents will be at liberty to file objection. In the meantime, if so advised.
May I please, Lordship? Your Lordship, my apologies. Here, we have to implement the Ministry of Human Resources Development and not
Okay,
Home.
change that. Instead of home, human resources development.
Yes,
Alright.
sir. Bless your Lordship.
For admission, item number 8.
So, Lordship, I'll be appearing on behalf of my senior, Mr. Ejimuni.
This morning. Yes.
If I may be allowed to read the last order, Lordship.
We have read it.
Lordship, I have
Now,
received-
9 and 10 are supposed to file affidavit, and just now affidavit has been supplied.
Yes, Lordship.
You're for 9, 10, and you're for 9.
I'm for the contracted
9.
respondent number 9, Lordship.
9.
My lords.
And as per the last court's order, you were directed to tell the court about the latest progress by
Yes,
filing
Lordship.
affidavit.
My lords.
So what have you stated in your affidavit? Where is that? This construction of, is it a construction of road or repair of road? Construction of road. Which road? Now again, road is already there. You're constructing another road. Then the present road is being renovated or widened or strengthened? What is the terminology? Sorry? Sorry? It's upgraded. Okay. And what is the, when did the work start? How many years back?
What was initiated in October 2020?
20?
No, Lordship, actually, it's like this in this case, how the present road has come into the present situation, come to this present situation is that the right of way was not given to the contractors, even though the contract was given and the date for beginning the work was also given to the contractor, but without getting the ROW, we were allowed to continue with the work, and that's how the work could not commence, Lordship. And the locals also created problems. It was initially it was supposed to be a 2-lane road, but because of all these problems, after this Honorable Court has initiated this Somoto PIL, only then there was a change of scope, and by the change of scope, instead of 2-lane, the present work that is going on is an upgradation of the existing road. So the actual work actually started in 2022, Lordship.
Cannot be 2022.
In 2022, Lordship.
The PIL was taken up as suo motu into 2022.
Yes, Lordship.
And if you see the first order of this code, it talks about 5-6 years back, since the road construction has been started, nothing has happened. So that is why the code was supposed to take it up.
That is why, Lordship. Why we could not work
No,
is because it's supposed to be a 2-lane road, Lordship.
Why you could not work is a different issue.
My lord.
But when was the work supposed to start? I don't think it's 22.
The appointed date is supposed to be 2020, but without giving us the right of way, Lordship.
And now when is it supposed to be completed?
Now, Lordship, it's supposed to be
And
completed
how
by
many
31st May.
how many extensions have been granted so far?
Few extensions, Lordship.
3 extensions.
One extension, only one extension. So after the change of scope, we have received one extension, and that is in our affidavit, Lordship. But my lord, my sincere apologies. There is one slide, a small typo error, a clerical mistake in the page number 2 of my affidavit for the respondent number 9, at paragraph 2. The first paragraph, Lordship. The paragraph at the top, paragraph 2,
Yes.
page number 2. The following is the progress report as on, it should be 6/2/2024. While entering the date, the previous affidavit, the date has been wrongly entered. If my lords may kindly allow us to make a correction now.
It should be 6/2/2024.
Yes, my lord. Yesterday.
In the second last column of the chart,
Yes,
work done value of total work in percentage. And end of the chart, we see it's 57.63%.
Yes, Lordship.
And you say that the completion time after extension is the month of May.
31st May.
31st May. How do you plan to complete by 31st of May?
In fact, Lordship, it is possible because after the change of scope, now further de-scoping is required for the fact that, Lordship, in some areas, working on the existing road, Lordship, we are falling short of several specifications. Not only that, Lordship, several works cannot be executed in the existing road, Lordship. So further de-scoping would be a minus of 20% and also a cut down on the bill amount, Lordship, the contract amount. So if my lords may kindly have a look at the page number 6, annexure 2, Lordship, of my affidavit. Now, my lord, if the de-scoping, which is impossible for implementation, Lordship, for execution of the work, which is impossible, if the de-scoping is granted, then, Lordship, the present progress would actually be more than 70%, Lordship. There are areas of work which is not executable, Lordship, which cannot be executed.
No, please come again. You were saying if
the de-scoping, that is annexure 2, page 6, we have written a letter to the authorities. May I read, my lord? Page number 6.
What do you mean by de-scoping?
There was a change of scope from 2 lane to 1 lane and upgradation of the existing road, Lordship. That's number 1. Now, in the upgradation of the existing road, there are certain specifications in the works that has to be executed by the contractor, Lordship. It is impossible to execute, Lordship. So we have written this letter. We are awaiting the response from the authorities at page number 6, annexure 2, Lordship.
Why is it impossible?
May I read, my lord? I'm not a technical person to be able to explain that to your lordship's satisfaction.
Read.
This is letter addressed to the General Manager, PNHIDCL PMU Jakama, Nagaland, date 4 January 2024. Subject, upgradation of existing road to 2 lane with paved shoulder from Kohima to Mau, from kilometer 185.540 to kilometer 211.709, design length, so and so, of National Highway 39, new National Highway 02, under National Highway NHO TSP in the state of Nagaland in EPC mode. Non-conducive site condition compels the determination of change of scope. Dear sir, with reference to the cited subject, it serves to inform that non-conducive site condition and series of events related to the change of scope implemented from date 2/6/2022 compels to determine a fresh change of scope considered as COS2 pursuant to clause 13.23. We would like to put forward below the compulsion for determination of a new change of scope, COS. 1. The change of scope was implemented from date 2/6/2022 with elimination for both of the paved shoulders due to non-availability of required ROW, Lordship. This is one of the main reasons. Due to non-availability of required ROW width of 18-36 meter mentioned under Schedule A. 2. During the preparation for change of scope, the available ROW width was envisaged as minimum 12 meters. Accordingly, the TCS were prepared for an approval and the value of the COS was rupees 120.18 crore contributed from several items with respective stipulated quantities. 3. We would like to draw your kind attention to the order of the Honorable Gauhati High Court, Kohima Bench, date 24/5/2022 regarding ROW issued, stated as taking into account of the fact that ROW issue has not been resolved and it may take some more time, we had directed all the concerned to go ahead with the construction of the road from Kohima to the border of Nagaland on the existing road and continue with the expansion after the ROW issue is resolved. 4. Further, the Honorable High Court on date 18/1/2023 made the following observations. In the affidavit of the contractor, it has been stated that the width of ROW is less than 12 meters. And this has created some confusion and it has led to delay in the execution of the work. The General Manager NHIDCL clarified that the contractor should continue the work within the available carriageway, whatsoever may be the size of the width. In fact, we have made this clear when this PIL was taken up. Thereafter, the contractor should continue the work without any hesitation. 5. Lordship, next page. Thereafter, while executing the layer works with respect to approved typical cross-section TCS, prepared with respect to ROW width of 12 meter. But on the contrary, the ROW widths of the contract length were found to be varying from 7 meter to 10 meter at maximum locations for which the compliance of Hill Manuel Indian Road Congress 48 was very difficult. Lordship, as per the manual, as per the IRC guidelines, Lordship, it should be 12 meters. And when it is less than 12 meters, 7 to 10 meters, Lordship, this is the next difficulty that we have faced after executing the work, after the change of scope, Lordship. Para 6, my lords. Whereas we had no other option but to comply Honorable High Court's directives to continue the work on existing ROW. At the same time, the quantities of several items have to be curtailed for inadequate ROW wheat. Therefore, a list was prepared with a proposal of items corresponding curtailment in quantities of certain items regarded for determination of negative change of scope for a value of rupees 20 crores 41 lakhs 97,970 as per Article 13.2 Clause 3 of the Construction Agreement. The detailed proposal is enclosed for your kind reference and perusal. In view of the aforesaid extraordinary situation, your good self is requested to verify and accept the submitted change of scope proposal with modification, if any, and initiate proceedings thereof in accordance with Article 13. Lordship, this is what we have, and the annexures are there. We have approached the authority for the impossibility of the execution of the work for the paved shoulders, Lordship, which will again further reduce the road, and there will be barely two vehicles, especially two heavy vehicles, will not even be able to ply, Lordship, cross section, Lordship. Lordship, that's the problem we are facing, and we have also approached the authorities. And if this is approved, my lord, the present work progress would come up to around 74 to 75% of the present road progress, Lordship. That's the present situation, my lords.
By this letter, you are seeking for change of scope.
In the change of scope, further de-scoping, Lordship, because it is impossible for us to.
No, because of the change of scope, you are unable to carry out the work.
No, because of the change of scope, we are able to work. But again, within the change of scope, there are certain specifications, standard specifications that we have to execute. And that is, as per the IRC, Lordship, the guideline, that the width of the road should be about 12 meters. Unfortunately, in many stretch of the road, Lordship, the width of the road is smaller than 10 meters, Lordship.
Okay. So, what would be the solution for that?
Now the solution is in those areas where the road is small. If we again go for paved shoulders, that will further reduce the size of the road where heavy vehicles will not even be able to, cross each other.
So,
to make it more practical, Lordship, unless the ROW issue is settled with the landowners and 2-lane, the road is going to be further extended. Before that happens, Lordship, the de-scoping is required for the convenience of the commuters, especially the vehicles, Lordship.
now if the width of the road is not sufficient, what would be the solution? To acquire more land?
Lordship, that is the lookout of the state respondents, and I believe they are also in the process of negotiating with the landowners. But Lord, here, after this case was instituted, it is to be understood in two parts. One is that because the road was in a pathetic condition, the upgradation of the existing road, that's one. But since it is an approved 2-lane road, that is the original intention of the union as well as the state authorities, Lordship, the respondents. So this Honorable Court has given a direction that while this upgradation of the existing road is going on, they should also resolve the issue with the landowners so that it can be extended to the original plan that is 2-lane road, Lordship.
So what is the status of that progress regarding ROW? Hmm. Hmm. Where is he? Where is he?
He's in dispose. He's in dispose.
He's in dispose.
Yes, Your Lordship.
However,
Hmm.
that as of now,
Hmm.
the state has got no part to play here.
No, the contractor is saying that they don't have the ROW at the relevant time, so they could not start the work. And now even after there's some modification, change of scope, they're still unable to perform the work because they don't have that sufficient land to conform to the standard width of the road. So what can be done in such a situation?
Lordships, if that be the case,
And why the ROW problem was there? The landowners are not getting compensation. Why was there obstruction?
I'm not
They,
aware.
they were not paid.
My learned friend is
Ah.
handling this case. Your Lordship.
In Team Song.
Yes, ma'am.
He was here yesterday, I think.
Hmm.
Was he here? In Team Song.
He was on leave and then he's in dispose. Your Lordship.
Mr. Joshua, what is the problem?
Hello.
The ROW thing was not available initially.
Yes,
That's
Lordship.
why you had a late start.
Yes, my lord.
Question is, why was there obstruction from the locals? Because
Perhaps
they
the
didn't get
compensation
paid.
has not been paid, Lordship.
They have not been paid.
They have not been paid a
So
compensation.
what has this court dealt with the compensation issue apart from the road? Has there been any instruction received by the councils
No, Lordship,
regarding
a
the
direction has
compensation?
been issued to the state respondents as well as the NHIDCL to settle the land issue. But as far as the compensation issue is concerned, that has not been dealt upon with, my lord.
No, it's not a separate thing, isn't it? To settle with the land issue means to settle
Yeah.
with the compensation.
In fact, your lordship,
If
yes,
the public gets paid, then they'll not have any complaint.
they have not been paid,
They have
lordship.
not been paid. That's why they're not allowing them to work.
There may have been an issue with the rate, a dispute between the authorities and the landowners about the rate.
Is it
Perhaps
acquired?
they've never arrived to a consensus because of the rate of the compensation of the.
No, the rate
Yes.
means, is it on a negotiated rate or it's as per the acquisition law?
In the village areas, lordship, especially the village areas, Dimapur area, the state government has a notification specifying the rates according to the commercial areas and all the areas have been mentioned under Dimapur district. But other districts, lordship, I'm not aware or if such notification exists.
No. Fixation of rates is a different thing. What I'm saying is that the acquisition of the land,
My lord.
how is it done? Is it as per negotiation?
No, as per the Act of 1965, the Nagaland Land Requisition and Acquisition Act 1965.
1965 Act.
My lord.
So
But that exercise that exercise has not been carried out by the state respondents, which is not my concern, lordship, but assisting this own court.
yes, definitely. Everyone,
lordship.
this is a PIL. It's not an adversarial litigation. So how is that acquisition being carried out then? Who is doing it?
It has to be done by the state and on behalf of the state, the district collector, the deputy commissioner, who is the district collector, will carry out that exercise.
Correct. So if the compensation is worked out, if the landowner is not satisfied, is there any provision for filing a reference or going for a higher amount? Like the 1894 Act,
Yes,
Land
lordship.
Acquisition Act, which has been replaced by the
Act of
2013.
My lord.
And we have the National Highways Act also,
Yes, lordship.
which again applies, in which the 2013 Act applies also.
My lord. I do not know why my learned friend said the state has no role, but actually it is the state and the union as well as the state has to work together with the landowners to solve this problem, Lordship.
Anyway, be that what it may be, as it may be, since you have been allotted the work,
My lord.
you are supposed to carry out the work.
Yes, Lordship.
Each and every step, you are facing problems.
In fact, before the ROW was received, when we tried to execute the work in some areas, we have faced physical abuse also, Lordship.
See, despite all that, you are showing that you have done so far, achievement is 57.63.
Presently, Lordship, after the change of scope
Ah.
in the upgradation work, Lordship, we no more receive any disturbance as such. There's no such disturbance, but according to the IRC guidelines, Lordship, the standard procedure that we have to follow, we cannot just do it because the Honorable Court says do it in some areas where it will become humanly impossible for two vehicles to even cross each other, Lordship.
The road is up to Maugate.
My lord.
Where, up to which stretch is it, the work has been done so far now, as on today?
In fact, the entire stretch, Lordship, major part of the work is over the DBM, but
No, you're doing the work gradually or you're working here and there? At selected places.
we've been working here and there, especially because of the during the monsoon season, Lordship, whichever area is the worst that we have been concentrating in those areas. But now there is a gradual process of work, Lordship. And till Maugate, Lordship, the initial process of the layering, Lordship, it has different stages which my lords are aware. There's barely any stretch which is in the situation, I mean, in the condition that was as bad as before, Lordship. And carpeting is also going on. The carpeting is up to, we have completed up to 24.58%, Lordship. That is the final stage of the work. And DBM 49%, WMM 60%, GSB and then EW. That is the first and the second part of the work. It's 100% complete, Lordship, in the entire stretch of the road. If my lords may kindly have a look at Annexure 1, page number 5 of my affidavit, Lordship. Of the 5 stages of work, 2 stages we have already completed 100%, Lordship.
So this annexure 1 has been abstracted in your paragraph 2, isn't it?
Yes, Lordship.
The same thing.
My lord.
Serial number 1 and 2, 100%.
Yes, Lordship.
Then what is the next column? Work done, value of total work in percentage. 100% is item wise. Then
Yes.
the other percentage is only 6.70%. What does it mean?
Oh, that is the 100% of the entire contract work included, Lordship. Considering the entire 100% of the work that we have to execute, Lordship. And Lordship, that is inclusive of the areas which cannot be, where the works cannot be executed also, my lords.
EW up to subgrade top. Top total quantity as per revised scope is 19 point so and so unit kilometers. Total work done is 19 point same thing. What is this in kilometers?
Yes, Lordship.
This is in kilometers.
Yes, Lordship.
Then the next one is work done percentage of item wise. Again, this is 100%.
Yes, Lordship. So this is with regard to specific work. There are many items of works, Lordship. So for a specific work, the EW up to subgrade top 100%, GSB 100%.
What is that specific work?
That's why it's completed.
what is that specific work? Item wise, you say, what is that item?
Work description, Lordship. Earthwork up to subgrade top.
Hmm.
So earthwork up to subgrade top, we have finished from the entire stretch of the road where we have to execute the work. The granular subbase, GSB, that also we have completed 100%, Lordship.
Okay, then you come to the next column. Then again, it comes down to 6.7% and 11.8%. What is this?
No, that is the overall work, Lordship, not item wise. The project cost percentage, Lordship. But it is overall work, overall work. Overall, my lord, will kindly appreciate that the earthwork up to subgrade top in the overall works that the contractor has to execute, Lordship, it comes to 6.70, Lordship. And all this percentage put together, item wise, Lordship, it comes to 100% at the end.
But this work done value of total work percentage, it all adds up to 57.63%. Isn't it?
Yes, as of now, Your Lordship. Later on, if the work is complete again, this percentage will go down because the other.
Okay, this work progress is from which period to which period? You say this is as on 6/2/2024, isn't it?
Yes, Lordship.
But what was the last progress?
The last progress. The last progress report that we have submitted, Lordship, is 51% in the month of November, Lordship. 29 November, Lordship.
29 November, 51%.
Yes, Lordship.
Then 6th of February, 24.
57.63%, Lordship.
Roughly about 2 months, is it? 29 November.
Yes, Lordship.
December and January.
Yes, Lordship.
Then you have progressed by how much? 6%. 6.36%.
Lordship.
Now, at that rate, if you say that May is the completion time, you'll not be completing it.
Lordship,
So that is why my question was, how do you intend to complete within next May? If that is the progress. And this letter is addressed to respondent number 10. Or what?
the letter,
Yes.
no, it's addressed to the NHIDCL, Lordship.
NHIDCL is? They are which respondent? One?
The NHIDCL.
Respondent number 1 is the Union of India Lordship. Mode.
Okay. So
2 and 8, NHIDCL Lordship.
2 and 8.
Yes, Lordship.
So you have received this letter?
Yes, Lordship.
How do you intend to proceed with it?
Lordship, we are to make a decision on this letter, Lordship.
4th of January.
Lordship, the procedure after receiving whatever the proposal submitted by the contractor, Lordship, we have an authority engineer appointed by the NHIDCL, Lordship, who oversees all the work on the site, Lordship. Now, basing on the recommendation of the authority engineer, Lordship, we take decision, Lordship. Now, after receiving this letter, Lordship, we have communicated to the contractor to write it to the authority engineer, Lordship, so that the authority engineer would verify on the spot and recommend us to take a decision, Lordship. And we are yet to take a decision on that, Lordship.
It has to come through the authority engineer
Exactly, Lordship.
appointed by the NHRDCL.
Exactly, Lordship. Exactly.
You mean there's a channel for that?
Exactly. Exactly.
Instead of going to the channel, they have written straight to the general manager.
Yes, Lordship. Yes, Lordship.
Why? Mr. Joshua, you know very well the channel, isn't it? You are not a first timer. You must be knowing that this is the channel. This is only to delay. In government jobs also, like 2-3 persons cannot collectively write representation to the authority. And somebody, a grade 4 person, cannot write straight to the chief secretary. It has to go through the channel like that. So you must be aware of that, isn't it? This is not solving the problem. If the authority engineer is a party here,
Yes, Lordship.
as respondent number 10, what are you doing otherwise? They are, no, don't say it's limited. See, they are doing all these things and you don't know anything about it. Authority engineer is not visiting the place or is not,
I am placed on site, Lordship.
you're placed on site.
They are also the-
So you know the difficulties, isn't it? You know the difficulties. Why let them write straight to the GM? They should first come to you, isn't it? That means you are not to be seen on site. That's why they are writing.
We are placed on site, Lordship.
Now, if you are on site, they should write to you. They should approach you. Let us see your affidavit. What have you stated in your affidavit?
Otherwise, Lordship, we have been reminding them to quickly progress with the work. Lordship. I don't know for reasons based on whether they have written to the GM, Lordship.
No, but the progress is not happening, you see. If the last date or the completion time is May 31st, and going by the last affidavit, wherein they say that as on 29th of November, completion is 51%.
Yes.
And after 2 months, there's only a work of 7.36%.
Yes, Lordship. We are also not
In
satisfied
addition.
with the progress, Lordship, which is why we have addressed the issue with the.
Let us see what have you stated in your affidavit. Respondent number 10, isn't it?
Yes, Lordship. In our affidavit, Lordship, we have not given the progress of the work, the status.
Your status in the status doesn't tally over.
Lordship, there's a slight difference because Lordship, we have included only those portions that is fully completed, Lordship. Whereas they have included the portion that is under progress also, which is why there is a slight variation in the figure.
For you, it's 55.92.
Yes, Lordship.
They say 57.63.
Yes, Lordship.
And what do you mean by financial progress?
It is the bill.
Bills.
Lordship.
There are pending bills as on today.
Just for about 3% or so, Lordship.
Why is not clear bills?
It is on the process of clear, Lordship. For the NHS, so from our office, we have already awarded it to NHS.
What is this last paragraph in page 3 below the chart? 2.6 kilometers stretch is under defect liability period
Yes, Lordship.
with the Nagaland State
Yes,
PWD.
Lordship.
This road was constructed by the PWD.
Yes, earlier, Lordship.
Earlier.
So, yes, the defect liability period is not that over.
So only after that period is over, the construction will take place.
Yes, Lordship. But with that, I think the Lordship, the progress that they have to achieve is that even under the present, this present condition is 98.60.
What you mean to say is that 100% is not required because this particular stretch is under the defect liability period. So achievement should be this much.
Yes, Lordship. National Highway, they are added as respondent number 12. Lordship.
So what would be the solution then now? They have not written to you. They have written straight to the GM. In so far as that difficulty they face. Now, what steps are you taking? GM has referred the matter back to you. Then how do they intend to proceed?
Lordship, the GM, they have forwarded the presentation or application written by the respondent number 9 to high office. The NHIPC.
So at any rate, the work is going on as on date.
Yes,
work is going on,
yes, Lordship.
and very soon the monsoon will come. They say the monsoon period is off season. We cannot work.
Which is why we
But the
have
work
also-
is to be completed before May, isn't it?
Yes,
By
Lordship.
31st of May.
Lordship. We have been reminding them time and again, Lordship, to continue with the work on that.
But where is that in your affidavit?
Not in this affidavit, Lordship.
That you're reminding time and again to complete. It's not there.
Yes. Since this already covered, was only to, all photo was, find the status report. Lordship.
Oh. We could have easily added that. We are doing our best, all that. Need not be directed, to write all those things. Miss Luceno, anything to submit?
Lordship can pass appropriate orders as per the affidavits which has been filed today, Lordship, since I have also received the affidavit this morning. Lordship.
Yes.
Lordship, may I make a submission with
Yes.
regard to the land acquisition, Lordship? If your Lordship may kindly turn to order date is 26th of July 2023, Lordship. 26th July 2023. This will make the things very clear with regard to land acquisition and compensation, Lordship. 26th of July 2023, Lordship. Also, I filed an affidavit on 25th of July. On basing on that affidavit, Lordship, this order was passed, Lordship. Lordship, we can turn 26th July 2023.
Yes.
Lordship's got it.
Yes.
May I read it from the second page, Lordship? The important, the affidavit filed by respondent number 1, 2, and 8, Lordship. If your Lordship's got it.
Yes.
May I read it, Lordship?
Read.
The affidavit filed by the respondent numbers 1, 2, and 8 has also been perused. In the affidavit filed by the respondent number 1, 2, and 8, the letter dated 26 May 2023, which is written by the Executive Director NHIDCL Headquarters to the Principal Secretary to the Chief Minister Nagaland. Second is the Senior PS to Deputy CM and Minister in Charge National Highway. Third is the Deputy Secretary to the Chief Secretary Nagaland. Fourth is the Executive Director RO Kohima. Has also been enclosed wherein under the heading Kohima Mao, it is stated as follows. This is a very important logic. Para 5, quote, it is mentioned that due to exorbitant rates of the damage compensation, the BAFE shoulder has been de-scoped from the present scope of the contract. Accordingly, the EPC contractor was directed to construct a road within the existing ROW lodge. NHIDCL is of the opinion that in the densely populated towns, to avoid relocation, displacement of public in large number, generally it would be beneficial if the town is bypassed. As stated above, the revised cost compensation for the stretch may not be required, Lodge. So this has solved the problem, and this honorable court has also made certain observations, Lodge. On the said letter dated 26th of May 2023, Mr. So-and-so, Leonard Amicus, referring to the order dated so-and-so passed by this court, submits that it is still imperative of the Union of India, that is the respondent one, to acquire the land under section so-and-so for completion of the project. Be that as it may, we are of the view that this court may not have the expertise to make a variant inquiry to what is stated in the clause 5 of the letter so-and-so. If your lordships may also kindly appreciate that there are several orders passed by this honorable court to construct a specific direction to the contractor to construct on the existing road, lordship. 2-3 occasions, lordship. And to be very specific, lordship, on 22nd of March 2022, lordship. Initially, lordship, 24th of March 2022, lordship. This happens to be the third order after registering this PILs. Lordship, specific order, specific observation has been made by this honorable court to construct on the existing parameters, lordship. So the question of compensation, acquisition of land does not arise, lordship. So at this juncture, lordship, my respectful submission before this honorable court, if a direction may be issued to expedite the progress of the work, lordship, we are also ready to cooperate and extend our help, lordship.
No, why does it require to pass an order every time to expedite the work?
To see the progress of the work, lordship.
This is what is bothering the court. Parties are not interested to complete the work. They have to be pushed every time. I don't know why.
We have seen the progress of the road comparing the previous year, lordship, but they have to expedite, lordship, subject to the authority engineers' recommendation, lordship, since the team of engineers are on the side, round the clock, lordship.
You are for the authority engineer, isn't it?
Lordship, I'm representing the NHIDCL, lordship.
NH, sorry, you are for authority, sorry.
So, Lordship, regarding the land compensation issue, Lordship, if my senior may be given a chance to assist this court, Lordship, I apologize today since I don't have the file today, so I'm not being able to assist this court, Lordship. So regarding the land compensation and land acquisition issue, Lordship, if my senior may be allowed to assist this court.
Surely, but see, he's in bereavement, isn't it? He's in bereavement.
Yes, Lordship.
And just now we read one, Mr. Mohad Jamil had shown us one order wherein Mr. Zimomi had also submitted that despite all these things, they still might have to acquire under the National Highways Act. But then court has said that we don't have the expertise to examine all these things.
In fact, it's a false chapter.
So now only the issue is in the present road, the construction has to be completed.
Exactly.
Somehow. I think all of you have traveled through that road.
Yes, Lordship.
Great
Go once in a
difficult.
while, actually, just to visit the progressive.
It's very difficult. It's in fact, when trucks are parked everywhere, you can't move also. And I've seen some places they've dug up half the road. Or is it meant for culvert or something? I don't know why. Only one vehicle can pass. And if there are so many trucks ahead of you, you are stuck there for good. So this is the situation now. This is the working season, I think. Now it seems like everyone is waiting for the monsoon to say that it's rainy season, so we cannot work. Okay, please write down. In terms of the last court's order, the respondent numbers 9 and 10 have filed their affidavit this morning. And the same has been placed before this court for perusal. Upon going through the affidavit of respondent number 9, it is seen that a chart has been prepared to show the progress of the work up to 28/11/2023. Mr. Joshua Sheki, Learned Counsel, however, submits that the same is a typographical error and it should read as 6/2/2024 instead. We have seen that the progress as on that date is 57.63%, while the extended time for completion of the work is 31st of April, 31st of May or April? May 2024. In the previous affidavit filed by the respondent concerned, the progress of work as on 29 November 2023 was 51%. It is therefore seen that since that date up till 6/2/2024, there has been further progress of work up to 7.36% only. Considering the progress, it appears that the work it will be difficult for the entire work to be completed during the extended period. Next para, Mr. Joshua Sheki, Learned Counsel for respondent number 9, has also drawn the attention of this court to the difficulties faced by the respondent number 9 in carrying out the construction work as per the standard specification prescribed in the Hill Manual, Indian Road Congress -48. Since the width of the ROW is not enough to carry out the road construction as per the standard specification. To stop, therefore, the respondent number 9 had written to the general manager bracket capital P NHIDCL, PMU Jakama, Nagaland. Bracket respondent number NHIDCL
8 Lord.
8 on 4/1/2024. Requesting the said authority to verify and accept the submitted change of scope proposed with modification. If any, and to initiate proceedings thereof in accordance with Article 13. What is this Article 13? Article 13 of what?
Yeah, the
Of
contract agreement,
the contract agreement. Next para, Mr. Moa Jamil, learned counsel for respondent number 8, however, submits that the said communication should have been routed through the authority engineer and not directly to the NHIDCL. Stop. He, however, submits that the matter is yet to be looked into and it will take some time. To stop, the learned counsel, Mr. Moa Jamil, has also informed the court that seeing the various difficulties faced, this court on various occasions had directed that the construction of the road should be limited on the upgradation of the work in view of the various difficulties faced in executing the work as per the original specification. Stop. The learned counsel has also drawn the court's attention to the order dated
September Lord.
26 September 2020.
May Lord.
26th May, is it? What is the date of the order?
26 July 2023. Sorry, for the incorrect date. Apologies. 26 July 2023.
26 July 2023. Wherein the court had expressed concern about the unsatisfactory progress of the work, and at the same time had directed the respondent number 9 to file a detailed affidavit showing the progress of work on the existing ROW. Next para. The respondent number 9 no, the respondent number 10, sorry, has also filed an additional affidavit wherein the physical progress of the work as on 5/2/2024 is 55.92%, which is in variation to the progress shown by the respondent number 9. To stop the difference in the percentage of work completed, according to the learned counsel for the respondent number 9, Mr. Santianger, is that
10, Lordship.
sorry, respondent number 10 is that the respondent number 10 has only shown the actual work completed, while the respondent number 9 has included the work which is currently being undertaken. To stop. Next para. Upon perusing the two affidavits filed by the respondent number 9 and 10, it can be seen that the work is hardly progressing, and the present and this being a working season, it is expected that the contractors and the engineers will mobilize all their resources to ensure that the work makes good progress. Full stop. This court expects that the respondents will, the respondent concerned will not spare any effort to see that the work progresses at a faster pace and in order to appreciate that the same is happening, the respondent numbers 9 and 10 are again directed to file an additional affidavit we'll give you a month's time. Today's 7. Within a month's time. To stop, the case shall now be listed again. On 6th of March. Make it 13th of March, 2024. The affidavit as directed should be filed on or before 11th of March, 2024. Clearly indicating the progress made. There's another thing which can be done. Okay, progress made. The affidavit also to be filed. The affidavit to be filed should also contain as to how the contractor plans to carry out the work up till 31st of May 2024. To stop. In other words, the affidavit to be filed should include what do you call that work schedule, isn't it? What? Sorry?
Work program.
Work program of the contractor. Clearly showing how the contractor intends to complete the entire work within the given date, within the extended period. Registry to list the matter again on 13th March 2024.
Bless you, Lordships.
Okay, we'll take a break. We'll come back in 5 minutes.
establishment there. Standing or standing
For admission, item number 13.
May I please answer?
Yes.
This is basically a covered PIL. Now, this pertains to a compensation claim for property damage. Now, herein already two judgments have been passed. One in the PIL itself, where that amount for this is basically for a stretch of road, construction of a stretch of road, where there has been some damage to properties. And ultimately, the government had assessed that compensation amount to 120 crores. Now, it ranges from four different sectors of four different roads. Different stretches of roads were there. Now, total out of that, one PIL was filed for one particular stretch of road, wherein around 60 crores was involved, and therein a judgment was already passed, and that amount has also been sanctioned now. It was not appealed, and the judgment was passed. It was allowed. The amount has also been sanctioned by the Union of India, and it's at the verge of payment. Some other repetitions were also filed during the pendency of that PIL also, wherein they had claimed for some other sectors or within that particular compensation package. Those were also allowed, and now that I think there's a waiting for this particular amount to be paid. Now, this PIL pertains to one small
think he has got the radio or something.
This live streaming things, these things are happening some days now. So this PIL is concerned for a very small stretch of that particular road from Juneboto to Chakabama under the Kohima district. Now that amount is for which this particular PIL is filed. I'll just place everything, then Lordship will come to know that everything is now been covered, and this PIL can also be disposed of in the same line.
See, in the last court's order, there's something mentioned about Delhi High Court's order.
I have seen that. Now, what has happened here in this is another aspect. Now, there is an arbitration matter which is pending. This amount of 120 crores, that amount the state is now trying to recover from the contractor, because the state as well as the Union of India, they say that whatever damage has happened to the property, that is because of your negligence while doing that entire construction road. Now that arbitration is between the parties, and we the public should not be within that ambit of that litigation. And more so, this issue of arbitration was already there pending during the first PIL order. Then the subsequent writ petition judgments were passed, and in fact it has been dealt with. It was argued in the PIL, though it doesn't find a mention in the judgment. It was also argued in those writ petitions, and it has been observed. But then that it has never stopped this honorable court from passing orders in favor of the petitioners and allowing those cases. So therefore, this issue of arbitration, in my humble submission, will not be a deterrent for your lordships to pass an order allowing the claims as made in these petitions by the public, the citizens who have actually suffered the loss. It is a matter of recovery proceeding that is going on in the arbitration between the state and the contractor. It is between them. We are not privy to that. We are not even privy to the contract between them or the arbitration matter. They are not party to that arbitration. It's a recovery proceeding that they can always do independent. Here we are concerned with the compensation to be paid to the public for the loss that has happened, and the compensation which has been admitted by the state and allowed by this honorable court on 2 counts for the other areas within that same particular package of that road construction. Yes, I'm placing that.
This is regarding the construction of road between Juneboto and Chakabama.
Yes, Juneboto, Chakabama, and that too, the Kohima district area only. The other parts, Lordship has already passed judgments.
Okay, Kohima district area.
Yes.
Now, these public or these landowners who have been affected have filed this PIL.
Yes, Lordship.
Seeking payment of compensation.
That admitted amount already assessed by the state.
Under what provision?
There was a spot verification that was done by them. But this is damage of property, not acquisition of land. When the road constructions were done, the
damages. Damages.
Damages, yes, Lordship. I'll just place those documents and also everything.
And the calculation is done under what provision? Damages.
The records would reveal that it was done based on a spot verification by the concerned department as well as the local public there. And
Concerned department means which department?
PWD. And that has already been accepted by the center also now, because in the PIL, when it was allowed, there was no appeal to that. And the money has already been sanctioned by the Union of India now.
Road is constructed by whom?
Road is constructed by a contractor called Midas Gayatri under a scheme called SARDP scheme, which has been financed by the Union of India, and the state have acted as an agency to supervise that particular work.
It's funded by the union.
Funded by the union.
Ministry
of National Highways and Roads. Also.
Okay.
Mount. I'll just place the judgments first, and
if that was the case, if
Yes,
that is the case, why was it not disposed on the last occasion?
because on the last occasion that view was there from the earlier bench, that should we wait for the arbitration judgment? Arbitration I had submitted otherwise, that arbitration between the parties. And in fact, Lordship Sema, who had passed the earlier order, he is a signatory to the PIL judgment. the judgment which was passed, the initial judgment allowing this amount, he was in that bench. Later on now, he had observed that the PIL is pending. So I think that order was, therefore, that arbitration is pending. So therefore, that observation was there. But be that as it may, already judgments are there now.
Arbitration was initiated under any particular clause?
Arbitration has, this is now a section 34 matter pending now. What had happened was, when this road construction was going on, at an initial point of this, around 2016, there was some lacuna in his part. The government had foreclosed his contract. Therefore, it took it up in a petition. There was the PIL first, then it went to the division bench, then the Supreme Court also. Therein, the Supreme Court had observed that whatever dues are to be paid between the contractor and the state, whatever exchange was there, it can be taken up in an arbitration. The foreclosure of the contract was allowed, and the separate contractor was appointed for construction of that road. Now, in that arbitration, the state has filed a counterclaim saying that 120 crores is the amount that we claim from the contractor, because while constructing the road, there has been damage to properties, and that is because of your negligence, so you are supposed to pay that money. The arbitrator...
Counterclaim.
Yes, counterclaim by the state. These are all admitted positions that I am submitting for lawsuit. Now, in that counterclaim, 120 crores was claimed by the state for negligence thereabout. So now, in the arbitration proceeding, what had happened was the arbitrator said that there is no evidence, hard facts on record to indicate how this amount has been accessed or how this calculation made, or whether the payment have actually been made by the state to the affected landowners or not. And therefore, the arbitrator in the award declined to enter into the counterclaim aspect, and on that aspect, it was rejected, which is on appeal under section 34 in the Delhi High Court, in the original code of jurisdiction. Now, that is one matter is going on. My submission all along has been that this is between them. It's basically a recovery proceeding. Once the state has accepted that a damage has taken place, and they have also quantified the damage and has claimed the damage from the contractor. So one thing is clear, that the amount is to be paid to those affected people. Now, how the state thereafter recovers or doesn't recover, it is at their peril, at their knowledge, how they do it. So this is a recovery proceeding. We, the public, should not be kept hanging on the fate of the arbitration.
Understand, but who will pay you now?
That's it.
Who will pay you now?
The Union of India, as per the judgments, as per the earlier judgments of this honorable court, I am saying this is a covered matter. As per the judgments of this honorable court, the observation, the direction has been...
Union of India will pay you and you recover it from whoever is concerned.
Exactly.
Is that the judgment?
The judgment is the state will seek for the proposal. The state will give the proposal. Thereafter, the fund will be allocated by the Union of India, which will be then disbursed by the district commissioner concerned to the genuine landowners. So proposal will go from the state, fund allocation will come from the Union of India, and thereafter it will be disbursed by the concerned deputy commissioner in the area concerned. And accordingly, in one stretch of that road, already sanctioned money has come, and the checks have also reached the deputy commissioner. So Union of India has been complying with the course of.
And the arbitration.
Yes, sir.
The arbitration, suppose it comes to a conclusion and liability is fixed upon a party. So if the Union of India is to get the money, they'll get the money from the party concerned.
From the party concerned, because their claim is against the contractor. Now, if suppose in section 34, the Delhi High Court held that yes, the contractor is liable to pay 120 crores, then that money will come and that will be adjusted between the state and the center.
And in the meantime, the landowners need not wait.
Exactly.
They be paid by the Union of India.
Union of India, which they are doing now. Which they are doing.
Where is the judgment? Let's see.
Yes, no, sir.
Who are our parties here in this PIL?
That's it.
Who all are parties? Respondents.
In which case, Lordship?
In your case, this
Yes.
PIL.
The Union of India is a party. Respondent number 1 is the Union of India. The state of Nagaland is the respondent number 2. And then the other officers are concerned. The concerned officers are there, Lordship. But basically, it's the Union of India and the state. Page 7, Lordship.
I'll just place the judgments, everything will be clear. In fact, in the writ petition, there were some writ petitions also as I submitted. A judgment has been passed by the single judge. Therein, in fact, this particular portion for which now it is PL amount we are claiming is also more or less been taken care of. I'll just place that also.
Yes, you have supplied two judgments.
Yes.
Which one? Which one you want to refer?
First is the PL 9 2019. PL 9 2019.
Yes.
Therein, if your lordship will come to paragraph number 3. Paragraph number 3 speaks about the particular road. This concerned project road.
This is a different stretch.
How's it?
Paragraph 3. The road is different.
No, same road, Lordship. This is the entire, there are total 4 roads under that package. We are concerned with the Juneboto Sakabama. Lordship will see that the last Fek Fujero and Juneboto Sakabama. I will just also submit one communication wherein a bird eye view, Lordship will get a bird eye view of the entire assessment. Before just going with the judgment, if you also will kindly see that communication, this gives a bird eye view of the entire compensation amount. This is a communication by the chief engineer to the contractor. Enclosure, Lordship will see the enclosure, abstract of claim for compensation. This is the entire 120.99 crore compensation assessment. Enclosed, abstract for claim compensation. That's what we got that. The next page is the abstract. This is the total amount. Now, Lordship will see that at serial number 1, name of the road is given. There are all these roads. Now, we are concerned with serial number 4, Juneboto to Sakabama Road. Therein, Lordship sees again the districts. Now, there are 3 districts. Fek district, 4A, Juneboto, 4B. This PIL is concerned with Kohima. Volume 4C. Amount is 4.70. Now, regarding the other 2 areas, the Fek district and Juneboto areas, this PIL 9, that the judgment that I have just given to your lordship, is concerned with, wherein this amount have already been allowed and the sanctions have also reached. So now I'll just place the judgment. These amounts, Lordship will see at page 6 of the judgment. Lordship can in fact compare from that abstract at page 6.
No, what is this letter about otherwise?
Yes. This letter is written by the chief engineer to the contractor, wherein he has stated that this is the total amount of 120.99 crore, which we have assessed as the damage. So, and this is because of the random dumping of excavated earth. So this is basically a communication from the state to the contractor saying that this is the amount that we have assessed. And the abstract is at the backside, the second page. And this is therefore was the amount that we have been claiming in the litigations. Because this is a communication by the state. That means the state have assessed this and this is an amount admitted by the state.
So basically it's a communication regarding assessment.
Assessment, which is therefore agreed, which is agreed by the state as the amount of compensation that is supposed to be paid.
Who has made the assessment?
The assessment has been made by the concerned department. I do not have those assessment paper with me right now, but these were the matters which were dealt with in that particular PIL, PIL 9 of 19. These issues were already discussed, dealt with, adjudicated upon, and then the judgments were passed on this abstract amount itself. I am not carrying those documents basically also, but then this is admitted by the state as well as the Union of India.
that this is the amount of compensation for property damage pursuant to that construction activities in these 4 lanes.
No, see, it says, I'm forwarding herewith the claim for damages occurred to structures, crops, irrigation, cultivation, fields, etc. during construction of instant work. This is a claim.
Yes, this is the claim. And the
It's
claim
not an
is-
assessment, it's a claim made.
No, that's what I'm saying is, the claim has to be based on some sort of an assessment.
So where is the assessment?
Assessment is, the entire assessment copy I'm not carrying because this is of 9 volumes. First you will see the details of claims that are enclosed.
So whatever has been claimed is as per the assessment.
Yes, Lordship.
Is that not in dispute
Not in dispute.
between parties?
No, not in dispute.
Not in dispute.
Not in dispute. In the affidavits also, they have said this is
Assess,
the amount.
assessment is made and this is the amount.
Yes.
So this amount has been claimed.
Claimed by the state upon the contractor for which this arbitration is now going on.
Correct. So now, as per this judgment, which you're going to read,
Yes, Lordship.
the direction has been given to the union to arrange the fund.
Yes. Funds have already been arranged. Sanctions are out. Sanction letter is there.
No, no,
Yes,
That is for PIL 9.
Yes, PL9.
no, the direction.
Yes,
Direction was given. Let us see what is the direction.
Lordship will directly come to page 9. In fact, it answers your Lordship's question because it's been written there. Page 9.
Yes.
Admittedly, I'm just reading the last paragraph.
Yes, we do.
Admittedly, the damage caused to the lands and properties have already been assessed by conducting a joint survey, and even the quantum of compensation amount to be paid has also been determined under the leadership and supervision of the Deputy Commissioner concerned. As such, the state government shall make the first move by submitting a proposal along with the assessment made to the central government / the ministry concerned, and on receipt of the same, the latter shall initiate the process of allocation of the funds and release of the same to the state government, who then shall disperse the same through the Deputy Commissioner to the district concerned to the genuine landowners whose properties, standing crops, trees, etc. have been damaged or destroyed during the construction of the road. The whole exercise should be completed within reasonable time, but not beyond 6 months from the adjustment. And the amounts, Lordship will find at page 6. Page 6 of the judgment. Page 6, at top, 4th line from the top. Fact Fujero,
Yes.
5.81.69 and Juniper Sakamama 55.12. Now, if a lawsuit will compare this with the abstract, this is the exact amount. Not been objected by either the Union of India or the state, and in fact, the sanction amount has also been made based on this abstract calculation itself. Therefore, in my humble submission, this may not be open for further adjudication as on date, this aspect. So this already is an admitted amount.
What about Zunepoto?
Junepoto, we have not claimed. His claim was made in the report, which
See,
judgment I will place now.
Page 6, which you just read out
Yes, Lordship.
of the judgment.
Yes, Lordship.
581 is the one figure.
581 is
Is-
fake Fujero.
Fake Fujero.
That you will
Fake-
Lordship will see at serial number 3 of the abstract. Serial number 3 of the
On
abstract.
that I've seen.
Yes.
Then 5512, this is regarding fake.
Yes, Lordship.
Then what about volume 4B?
Volume 4B was not claimed in this particular PIL.
I see.
Because Junegoto is a different district.
Oh.
That PIL had come from the FEC district.
Okay.
So therefore, it was not claimed.
Any other PIL then?
Lordship.
Any other PIL for Zuneboto?
Yes, there were writ petitions been filed.
Which is the one? The
That is the second judgment that I have placed. Lordship.
okay, WPC 146.
Yes, Lordship, 146.
Okay.
I'll just come to that also. So now Lordship will see that for this particular in the PIL, this judgment was passed, and this is pertaining to the FEC Fujero Road and Junegoto Sakamama Road, the volume 4A, that is the FEC area. Junegoto was claimed in the writ petitions, the second judgment, and this PIL concerned is for that Kohima area, volume 4C area of 4.70. So this is the position. Now, the Lordship will come to the judgment in the writ petition.
Yes.
WC number 146. there were a lot of repetitions. They were all clubbed together and this judgment was passed on 21/11/2023. I will take your lordship to paragraph 20. It speaks about the PIL judgment first, that your lordship will find at paragraph 18, page 207. Page 207 at the bottom, paragraph 18.
Yes.
At this stage, it is necessary to refer to another proceedings in the form of public interest litigation, PIL 9/19. So it thereafter extracts those relevant paragraphs of the judgment. And then what will be relevant for lordship's consideration is at page 20 now. Page 210, paragraph 20.
Yes.
You just read that. Paragraph 20, page 210.
Yes.
The bottom.
Yes.
This court on 14/11/2023 had asked the learned Central Government Council and the learned Additional Advocate General Nagaland to provide a proper breakup of rupees such and such, showing how much figure has been reached, how the figure has been reached, and the basis on which the respondent Union of India and the respondent state of Nagaland authorities made their counterclaim before the arbitral tribunal, and thereafter have perused the claim for the said amounts in the proceedings presently pending before Delhi High Court. In deference to the order dated such and such, Mr. Sanktam, learned Additional Advocate General Nagaland, has placed a communication bearing number such and such dated 16/11/2023 of the respondent number 5. The abstract enclosed with the said communication read as under. This abstract has to be given a bit of an understanding, lordship. The first abstract, if your lordship will kindly see, the first abstract is regarding the PIL 9/2019. Lordship can have that abstract on the other side, beside your lordship, and then can compare. Now, PIL 9 of 2019 is the first abstract. So, in this letter, they have indicated what is the particular amounts and the particular stretch of road that is concerned. They say, serial number 1, Fek Fujero, the amount is there. Sakabama, Junepoto, volume 4A. Now they have referred to the volumes of compensation. Volume 4A, 5512. Now comes the second abstract. Now in the second abstract, lordship will see the concerned roads are, and this tallies with that abstract. Longleng Santamia Road, Mon Tamlu Verangkong Road, and 3 Kohima, volume 4C. This is the amount that we were claiming in the PI. So this has also figured in the writ petition. Now our PI was pending when this matter was taken up for adjudication. And the third abstract deals with the Junevoto Sakabama area of Junevoto Sakabama that your lordship was just asking me as to what about the Junevoto area, 881. So now therefore the judgment have given 3 abstracts based on a communication from the state. Now lordship will kindly come to paragraph 24. Paragraph 24. Paragraph 24 indicates that these cases are squarely covered by the judgment passed in the PIL. Are also fully applicable in the case respect of the case of landowners. This court finds that the observations recorded by the division bench in PIL 9 of 19 in the order dated 31/2023 are also fully applicable in respect of cases of the landowners of the adjoining the roads has been recorded. So thereafter, the final direction is at page 214, paragraph 26.
Yes, please.
After admission of the claims for damages of the landowners, as shown in the first abstract table above, and sanction of the amount of 60.94, it is not open for the respondent authorities in the Union of India and the state of Nagaland to take a different stance in respect of the other abstract tables. In view of the same, the first batch of writ petition as well as the second batch of writ petitions are disposed of with a direction to the respondent authorities in the MORT, GOI, and the respondent authorities in the state of Nagaland to initiate the process of allocation of fund in consultation with each other. This is very important in terms of the second abstract and the third abstract extracted below above, provided via communication dated 16/11/2023, and thereafter allocate the requisite fund to the jurisdictional deputy commissioner, who shall in turn disburse the same to the genuine landowners. I'm just pausing here for a moment. Therefore, in essence, otherwise, this judgment has also included my cause of action or my prayers in the PI, because in effect, what has happened is, now this is a judgment in person in rem now. His lordships have said that whatever is there in abstract 2 and abstract 3 should also be now cleared based on the judgment of the PIL, and therefore it has to be paid by the deputy commissioner to the concerned genuine landowner.
Okay, otherwise this writ petition was regarding which stretch?
Regarding the other stretches, whatever is in the abstract, barring or except the Kohima area. All the batches of writ petitions were for those areas, but when the abstract was given, I mean, when the communication was made by the state before this honorable court and these abstracts were given, they have also included the Kohima area.
No, I understand that, but things that this writ petition was directed against which particular stretch?
The other stretches, Lordship, that from the abstract, if your Lordship will see, stretch number, that's serial number 1.
Page 211. Page 211.
211, yes. Through or that abstract from the communication that I have placed earlier. That entire abstract. That communication.
Yes.
That 2-page letter, that claim comes.
Entire stretch means 1, 2, and 3.
1.
Except for 4.
2. No, I'm just 1, 2. 3 is not there because 3 was in that PIL.
Okay.
Because this is concerning fact district. And then the Juneboto Chakabama Road, they have claimed for the Juneboto area. On serial number 4, Juneboto Chakabama Road, they have claimed for the Juneboto area.
So this writ petition which you're referring to,
Yes, sir.
146, is regarding serial number 1.
Juneboto Chakabama. Possibly is referring to page 212 of the writ petition of the judgment.
Yes.
Writ petition WPC 146 to 186. Because I have not given the entire area of those parties because it's 215 pages. I just got the judgment yesterday night.
No, this judgment is only for one writ petition. It's not a common judgment.
It's a common judgment. I have not given all the areas of party. If you will see, there are total 215 pages in this judgment.
Oh.
But I got this judgment.
How many writ petitions?
Okay.
How many writ petitions?
Yes. From 146 to 186, that is 40 writ petitions.
146 to 186.
186, that is 1. And from 82 to 87, that is
82.
WBC number 82
to
WBC number 87.
Okay. These are the writ petitions involved.
Yes, sir.
Okay. So they covered all the areas.
The single bench judgment otherwise have covered the entire areas also. I mean, including the claim in the PIL area also.
PIL 9 was for?
PIL 9 was for serial number 3.
Fake and Juneboto. Yes.
And serial number 4, Juneboto Sakabama Road concerning Fake district. That is Fake volume 4A, 55.41.
No, PIL 9 was for Juneboto Chakabama Road. For
Sakabama Road
For fake and Zuneboto.
Concerning that fake area.
Not Zuneboto.
Not Zuneboto. Lordship will see that abstract. The abstract that I had given by way of the communication.
Yes, yes. I've seen
Serial
it.
number 3, Fake Fujero Road. Fake. That is a part of the PIL. And
PIL 9.
PIL 9, yes, Lordship. And
Serial number 3, isn't it?
serial number 3. Serial number 3 in entirety is a part of the PIL 9.
Okay.
And then serial number 4, Juneboto Sakabama Road, only FEC. It's been again subdivided into 3. FEC, volume 4A, 55.212.
Okay.
So this was the scope of PIL 9.
Not Zuneboto.
Not Juneboto.
Only fake.
Only FEC. This was the scope of PIL 9. The rest, except that Kohima stress, was the subject matter of those writ petitions.
Okay.
But while giving that communication by the state to this honorable court, where these abstracts were thereafter been extracted, therein, however, the Kohima part was also included, and the judgment when it was passed, his lordships have been pleased to pass a judgment in rem, saying these entire people are supposed to be paid. So therefore, in view of that judgment, which is also not been appealed as I have been informed, also can take a break.
Yes. Otherwise, why do you require a separate judgment? If it's a judgment in rem, you could have furnished that copy.
Yeah, my PIL
That
was
I'm covered by this.
Otherwise, this PIL was pending at this point of time. When the judgment was delivered, this PIL was pending. So today the PIL has come up for hearing. Now I need some sort of an effective order in this PIL to cover this aspect. If a lawsuit records these findings of the single bench and the PIL matter and closes this matter, I think that will suffice. But just to withdraw a PIL, probably. Because again, this is a writ petition not been filed by us. I do not know what is the fate of these petitions tomorrow. I need to be covered in my PIL matter.
And you were saying that there's already some process of payment.
Process of payment?
Sanction and payment.
Yes, I can produce a sanction letter.
Regarding PIL 9.
PIL 9, yes, Lordship.
All right, we'll come back at 2.
Yes, Lordship. Yes, Lordship. These aspects it can be disposed of. Sanction letter.
This PI one is
No, entirety I have not taken out. I understand. He is asking for the. I have not printed out.
definitely
No, I have taken out all the papers.
Yeah, on this.
So I didn't take out. I came to remember a judgment yesterday. I just took out whatever. I have changed party.
Sanction orders. And the petition. Judgment still is not.
May I please, your lordships? Your lordships, if I may be allowed to make a mention, your lordship. Item 21, your lordship.
Yes, 21.
Your lordship, here I am paying for response number 2, your lordship. Lordship, if the matter can be posted on 14, your lordship, next week for hearing, your lordship.
You are for?
The response number 2, your lordship.
Who's respondent number 2?
Your lordship, the private respondent, your lordship.
No, but I mean, what is your role? You are the informant?
Yes, sir.
Informant or the victim?
Informant, your lordship.
Informant.
Lordship.
What matter is this?
Here,
Under what section?
under section,
POCSO?
yes, POCSO,
Ah.
section 4 and 6.
20 years.
Lordship, the matter can be posted on 14, your lordship, for hearing, your lordship. It's reflected in the order, your lordship.
Who's for the appellant?
Lordship, I'm for the appellant.
Okay. You're ready otherwise?
Yes, Lordship.
Okay, posted on 14, but there are other matters also posted on that day.
Yes, your lordship.
You could have taken your chance today. All right, anyway, on the prayer made by learned counsel for respondent number 2 and not objected to by the other side. Is the matter again on 14th of February 2024 for hearing. Is it for hearing?
Yes, Lordship.
It's
paper-
on orders, Your Lordship. It
Oh,
may
why?
be reflected on hearing, Your Lordship.
Why is it for orders today? Give me the
Lordship, in the
fact.
last instance, Your Lordship, respond number 2, Your Lordship, within appears.
All of you have got the paper book?
Yes, Lordship.
Okay.
March.
We were on item 13.
13. I was referring to that sanction
Yes.
pursuant to that judgment in the PIL, the government sanction. I'm just placing that for losses prevention. On 27th October 2023.
Yes, you are audible.
I'm audible.
27 October 2020.
Yes, Lordship. So this is regarding that PIL amount of 60.94 pertaining to the FEC Fujero and Juneboto Sakabama Road concerning that area only regarding that FEC district. So this amount has already been sanctioned. The money, to my instructions, have also reached the Deputy Commissioner FEC, and they are in the process of now verification and possible disbursement.
This letter which you have given me, the amount pertains to volume 4A and 4B. Is that correct?
Volume.
Juneboto Chakabama Road.
Yes, it
and
pertains to
FEC and Juneboto.
It pertains to volume 3 and volume 4A.
Acha, volume 3 and volume 4A.
Yes, FEC Fujero Road, volume 3, and under the Juneboto Sakabama Road, FEC volume 4A. If Lordship adds up the both the amount, it's 60.94.
Okay. This is by the MORT?
Yes, from the Union of India.
Informing the thing. Okay.
Yes. This is the position. Lordship can observe these developments and close this PI.
Do you have this abstract with you? Abstract which you just
Yes,
gave me?
Lordship, I have.
Let us go through that abstract again.
Yes, Lordship.
Now, PIL 9
Yes.
pertains to FEC.
Serial number 3, FEC Fujero Road, FEC volume 3, amount is 5.81. And serial number 4, Juneboto Sakabama Road, FEC volume 4A, pertaining to the amount is 55.12.
These two.
These two.
Only.
And in the batch of writ petitions, the other amounts pertaining to the other roads, all the other sections of the roads, are being included.
Then this serial number 4. Kohima.
Yes, serial number 4.
This pertains to the present PIL.
Yes.
And the pertains to that bunch of cases which you had referred
Writ
to.
petitions. Yes. Yes.
You don't have any sanction order for the others?
The order have come only on 23/11, and the period of time given is in the judgment is 6 months. Till now, the sanction has not come.
Now, do we have to make a reference to the arbitration thing and all? Is it required?
In my submission, it is not required. Because it's already been observed in the batch of writ petitions also that it has been dealt with. It's not been dealt with in such, but it has been always, that reference is always there.
Yes.
My submission regarding the arbitration issue, it was never an issue that has been always brought in by the state. In fact, the state or the Union of India have all along been saying that yes, this amount, we itself have claimed it from the contractor. There has always been an admission on this part.
Is there any observation anywhere in this two orders, PIL 9 or this WPC 146.
In PIL 9, there has been no reference now in the judgment, but it was argued.
It was argued.
It was argued. And
And
two judgments were also placed.
And in 146?
And in the writ petition, your lordship will see at paragraph 20, page 210, the court has made an observation regarding the counterclaim before the arbitral tribunal.
What is the status of the counterclaim? It was dismissed.
It was dismissed.
And the arbitration itself is still pending.
No, arbitration is, the award has been passed in the arbitration.
And appeal has been
Thereafter, an appeal has been now preferred by the state under section 34 before the Delhi High Court.
Okay.
Because the counterclaim was rejected. But we are not a party to that, so therefore, we are not privy to what is happening. And my argument or my submission would be, an arbitration is between the parties signatories to a contract. So any third party will therefore not be included or it will not have any effect in third party. It's between them.
All right. So who's for the respondents?
For this one number 1, 3, and 4. Lordship, I have filed my affidavit, but my early submission is that there is an arbitration case pending before the Delhi High Court. So the matter is up to the
1, you're for 1,
3,
3, and 4. Okay.
That is my only submission, Lordship.
Okay. And state? You are for?
5, 6, 8, 9.
Okay. What do you say to the submission made by Mr. Sharma? Covered case.
I may be allowed to make small submissions here.
Surely.
Pertains to PIL 9 of 2019.
Yes.
Whereby the judgment and order was passed on 30th January 2023.
Yes.
Pertains to Chagasang Public Organization PIL. In the very judgment and order, there is no ambiguity. And if I may be allowed to read your lordship at the last paragraph, which my learned friend had deliberately referred to. May I read your lordships?
Yes.
Admittedly, the damage caused to the lands and properties have been already assessed by conducting a joint survey, and even the quantum of the compensation amount to be paid has also been determined under the leadership and supervision of the Deputy Commissioner concerned. As such, the state government shall make the first move by submitting a proposal along with the assessment made to the central government / the ministry concerned, and on receipt of the same, the latter shall initiate the process for allocation of fund and release of the same to the state government, who then shall disperse the same to the Deputy Commissioner of the district concerned, to the genuine landowners whose lands, properties, standing crops and trees, etc., have been damaged or destroyed during the construction of the road. The whole exercise shall be completed within a reasonable time, but not beyond 6 months from the date of this judgment and order, your lordship. Here, basing on this judgment and order, your lordships, the Government of India, Ministry of Road Transport and Highways, by letter dated 27 October 2023. Your lordship, if I may be allowed to furnish this.
Here. Already
Here.
No, see, you're repeating the same thing again.
Your lordships, I have a grievance here.
What grievance?
In the second para, if I may be allowed.
Yes.
To I'm directed to refer to sanction letter number such and such, dated 9/12/2010, and to convey the administrative approval, technical approval, and financial sanction of the President of India for the payment of award based on the order of Honorable Gauhati High Court, Kohima Bench dated 30th January 2023 regarding damage compensation amounts to rupees such and such. Based on the calculation of DC pack for the work mentioned in the subject above, subject to the condition that the amount shall be recovered from the agency charges of the state PWD of Nagaland. We are agreed by this. No mention is made in the judgment on order passed on 30th January 2023. The employer is the Union of India, and the state respondent is only acting as a supervisory agent, Your Lordship. That is how we have submitted 3 representations to the ministry concerned. And if I may be allowed to furnish, Your Lordship.
Representations?
Representations made by the state respondents.
The person to this letter?
Yes, Your Lordship, which was in connection with the contempt petition being filed by my learned friend in the PL 9 of 2019, Chakasang Public Organization, Your Lordship. May I read, Your Lordship?
Just a minute.
Which was written on 23rd November 2023.
So what is the reply?
Still awaited, Your Lordships. And second is also written by the Chief Secretary. Third by the Deputy Chief Minister of the concerned department. And we are still awaiting the.
No, this you will resolve amongst yourselves later on.
Since Your
Where-
Lordship,
where is the immediate-
nothing is reflected in the judgment on
No,
order.
that's okay. That we can see.
And what about the, if I may be allowed to refer about the agency charges? I have already furnished.
What do you mean by agency charges?
That is why I wish to read out, Your Lordship.
Where?
Here.
From where?
I have the copy.
Back to my humble submission, these are issues beyond the scope of this PI, because this is something between the state and the center as to how they are going to adjust this money later on.
May I read, Your Lordship?
You give us a copy first. If you have one. But this is an interesting thing, you see. There was one case in which land was to be acquired. And the agreement signed between the parties was that the state will pay the the authority or the organization for whom the acquisition was made will pay the charges. What was exactly the term? I don't remember. It says charges, some charges like that. So this organization now says that we are not supposed to pay the compensation.
Yes.
We are only to pay the nominal charges for the process fee or something like that. So they were trying to move out of their liabilities. Obviously, Deputy Commissioner acting as a collector does all the acquisition process. Government notifies. That was another 1894 Act. And the agency or the organization for whom the acquisition was made is trying to slip out, referring to that clause, saying that we were only to pay the charges.
But then there was an agreement between them. As a lawsuit.
So that was very interesting.
Your Lordship, here.
Otherwise, normally they are to pay whatever has been assessed. They have to deposit before the collector who will disburse it. Now they took a stand that no, we are only to pay the what you call, like in the bank you have the charges, nominal charges, process fee or something like that.
The state respondent is solely depending on the Union of India, of the ministry concerned. And in case, if we are to realize to recover this amount from the state agency charges, this project will be as good as state project, not the central project. So
what is the agency charges?
May I read, Your Lordship,
Yes.
in running page 3?
Page 3.
Yes, Your Lordship. 1.4, agency charges.
Yes, please. It's all black and-
1.4, agency charges. The agency charges are mean to cover the following items broadly. 1.41.
Got it. I understood it. Yes.
So this is meant for.
These are office expense.
Yes, Your
Miscellaneous and all that.
Your lordships. So if the recovery is to be done from this,
No, that you sort out between you and the ministry. Because they also know very well. Why should the state be burdened with repaying the amount, isn't it?
we have submitted our proposal to the ministry concerned for construction of this 2 lane. And if we are to recover the amount from
No,
the.
we'll reflect this in the order. We'll reflect this in the order.
Yes, Your
Whatever kind of agency charges which has been mentioned, there's already a communication between the parties concerned, and it should be sorted out by them.
But nothing was whispered nor reflected in the first judgment on order, which was passed on 30th January 2023, Your Lordships. State is only a mere agency of the ministry.
No, that is an
So as
accept-
to supervise.
That is the undisputed position. It's not mentioned anywhere. Then why should the court mention also that state will pay?
Nothing is mentioned.
Everyone is depending upon the ministry center.
That's when the PIL was very categorical. It has said that they will send a proposal and the Union of India is going to sanction that money. According to the sanction has been there. But now Union of India wants to recover it. But then I would submit that that is a separate aspect altogether. Nothing to do with this disbursement of money insofar as the PILs are concerned or the deputies are concerned.
We are the HN and the Union of India
State
is
and
the
center can
employer.
always take it up among them through their own channels.
I understand. You have a point. We'll reflect that in the order.
Yes, sir.
Heard Mr. Anshuman Sharma, learned counsel for the petitioners.
LT Sankam.
Mr.
LT Sankam.
LT Sankam,
Additional AG,
learned additional AG,
assisted by Ms. Zimomi.
assisted by Mr. V. Zimomi, learned senior government advocate, junior government advocate for the state of Nagaland, bracket, respondent numbers 2, 4.
No, Your Lordship, 2, 5,
2, 5,
6, 8, 9, and 10.
2, 5, 6, 8, 9, and 10.
Yes.
Close bracket. Comma, Mr. Yangarwati, learned CGC, appearing for the respondent number 1, 3, and 4. And
I'm for respondent number 7, Lord.
Mr.
Jamir, Lord.
Sorry?
More Jamir, Lord.
Moa Jamir. Learned counsel for respondent number 7.
Lord.
What about 11? 11, anyone appears? MS Maitas Gayatri.
No one.
No one has appeared.
No one appears for respondent number 11. Having regard to the nature of the case projected by the petitioners, the writ petition is taken up for disposal. At the admission stage. Next para, by filing this public interest litigation, PIL, the petitioners who claim to be the land owners affected
We
by
are
the
espousing the cause of the land.
Oh, okay. Okay, it's like that.
The list is at page 79.
The petitioners, who are the prominent citizens of the state, have sought to espouse the case of the landowners affected by the construction of what is this? What is the stretch of the road?
It's called Zuneboto Sakabama Road.
Zuneboto Chakabama Road. Zuneboto dash Chakabama Road.
Yes.
Undertaken. What is this SARDP?
SARDP is accelerated
Undertaken under the, sorry?
Running page 88. Special Accelerated Road Development Program for
88.
Northeast.
Where is that? 88
Your Worship, running page 88 of the writ petition. Sorry, PIL 1.
It's the statement of counterclaim and next step. So it's written.
No, 88 is something else. It's an order. Arbiter Tribunal.
The full form would be
Okay,
also
okay.
Special
Under-
Accelerated Road Development Program.
Undertaken under the Special Accelerated Road Development Program for Northeast. Bracket SARD PNE. Bracket again. Face capital A. The affected persons are residents of the area concerned, having their respective lands, and the construction of the said road has damaged their properties. Stop. According to the petitioner, an assessment has been made by the district collector concerned, along with whom?
It's running page 79.
The assessment sheet is at page 79. Yes, from 79. Signatories are there.
Who are these?
Basically PWD, the commissioner, deputy commissioner, the extra assistant commissioner, sub-divisional officer, joint junior engineer, PWD, sub-divisional officer, PWD. It was a joint verification committee.
What did I say, please? Can you repeat last line? The authorities under the State Public Works Department. Full stop. The Chief Engineer, Public Works Department, within bracket NH, Government of Nagaland, White communication dated 5/9/2017, informed the respondent number 11 regarding the assessment made for the damages caused due to the execution of work, which also included the stretch of road referred to in the instant PIL, that is Zuneboto to Chakabama Road, in respect of Kohima district. To stop, the assessment has come to the tune of rupees 4,70,09,719.74. Stop. Despite the said assessment, since the amount of compensation was not paid to the landowners, the instant PIL has been filed. Next para. Mr. Anshuman Sharma, Learned Counsel for the petitioners, submits that a number of writ petitions and also a public interest litigation was filed by the affected persons and the writ petitions have been since disposed of by directing the amount to be paid to the respective landowners. To stop. In this connection, the Learned Counsel refers to a common judgment a common order dated 21/11/2023, passed by a single bench of this court,
was relying on the PIL system.
wherein WPC number 146 of 2021 was the lead case. To stop. The learned single judge, by taking into consideration the amount that has already been assessed by the competent authority for the various construction works done under the said project, and importantly, taking note of the order dated (31) 2023, passed by a coordinate bench of this court in PIL number 9 of 2019, disposed of the writ petitions Where's the operative portion?
Paragraph 21 is the abstract and paragraph 26 is the operative portion.
No, where's the direction?
Paragraph 26.
By directing the respondent authorities in the Ministry of Road Transport and Highway, Government of India, and the respondent authorities in the state government to initiate the process of allocation of fund in consultation with each other in terms of the abstracts given in the said order. And thereafter to allocate the requisite fund to the jurisdictional deputy commissioners, who shall in turn disburse the same to the genuine landowners whose land, properties, standing crops, etc., have been found to be damaged, destroyed during the execution of the work concerned. Full stop. Next para, it may be mentioned here in that in view of the arbitration clause in the agreement signed between the contractor and the state, the claim made by the contractor and the counter claim made by the state government was taken to arbitration. The arbitration was allowed in favor of the contractor, while the counterclaim of the state was dismissed. To stop against such decision, the state has filed an appeal under Section 34 of the Arbitration Act before the High Court of Delhi, which is said to be pending as on date. To stop. However, since the same is an issue between the parties concerned, the same did not deter this court, the single bench of this court, in disposing of the writ petition, vide its order dated 21/11/2023. Next para. The order dated 31/2023 passed by a coordinate bench of this court in PIL number 9 of 2019 which was in fact relied upon in the common order dated 21/11/2023 by the learned single judge. On being produced by Mr. Anshuman Sharma, learned counsel, has also been perused by us. In the said judgment, this court, upon considering the fact that an assessment has already been made by the competent authority, directed the state government to submit a proposal along with the assessment to the Ministry of Road Transport and Communication, and the latter, upon receipt of the same, should initiate the process of allocation of fund and release the same to the state government, who shall then disburse the amount through the Deputy Commissioner concerned to the genuine landowners. Whose land and properties, standing crops, trees, etc. have been damaged and destroyed during the construction of the road within a time frame of 6 months from the date of the judgment and the order. The learned counsel for the petitioner submits that the instant PIL is squarely covered by the two directions referred to here and above, and the same can be disposed of in similar lines. To stop, the learned counsel further submits that pursuant to the direction, the Ministry of
Road
Transport and Communication,
Highways.
Road Transport and Highways. I said communication sometimes, no? You convert into highways. Has already made a sanction for the required fund for payment to the landowners concerned in terms of the assessment made and has communicated the same to the Commissioner and Secretary to the Government of Nagaland, Department of Works and Housing. Wide letter dated 27/10/2023.
Your Lordship, sorry for interrupting. Specifically for PIL 9 of 2019. Yes.
To stop the said sanction of fund cancel that. The learned counsel submits that the said sanction has been made in respect of the amount covered by PIL 9 of 2019. And therefore, a similar direction may be issued in the instant case. The learned counsel further submits that the learned single judge, in its order dated 21/11/2023, in fact, had also made a reference to the amount of compensation assessed for those affected in the construction of Zuneboto Chakabama Road for the district of Kohima. In paragraph number 21 of the said order. Stop. Therefore, since therefore it is clear that the present case is squarely covered by the directions already passed in the bunch of writ petitions disposed of by order dated 21/11/2023 and also the PIL number 9 of 2019. And as such, similar direction may be given to the respondent authorities concerned. Next para. Mr. Gauhati, learned CGC, appearing for the respondent numbers 1, 3 and 4, submits that pursuant to the decision taken by the arbitrator, the state has preferred an appeal under Section 34 of the Arbitration Act before the Delhi High Court, and the outcome of the same is still awaited. To stop that. Okay. File appeal before the Delhi High Court. What did I say? Okay, out there. State as well as the Ministry of Road Transport and Highways.
We have appeal for counterclaim, Your Lordship.
Okay.
State has claimed for counterclaim.
Have filed an appeal before the Delhi High Court and the outcome is still awaited. To stop as such, the present writ petition, a present PIL may be kept in abeyance pending the outcome of the said appeals. Next para. Mr. LT Sankam, learned additional AG, for the state respondents, submits that against the dismissal of the counterclaim made by the state before the arbitrator, the state has also preferred an appeal before the Delhi High Court. And the outcome is still awaited. To stop, he further submits that although the Ministry of Road Transport and Highways in PIL 9 of 2019 has accorded sanction for the assessed amount, but the same has been made with the condition that the amount shall be recovered from the agency charges of state PWD of Nagaland. Stop. The learned additional AG submits that the state government is only a
Supervisory agent.
supervisory agent and it cannot be fastened with the liability to compensate the landowners for the damages caused by the contractor who executed the work. Stop. He therefore submits that no liability can be fastened upon the state government for recovery of the amount disbursed to the affected persons. Next para. Upon hearing the learned counsels for the rival parties and on perusal of the materials available on record, we are of the view that there cannot be any impediment in disposing of the instant PIL. In view of the fact that there is no dispute with regard to the amount so computed by the authority concerned. So moreover, the amount which has been computed in respect of the other areas, districts, where road was constructed and damages have occurred, have also been quantified and sanction for the same has already been made. To stop, in fact, the land, the land covered, the amount covered by PIL 9 of 2019, as already mentioned here in above, has received sanction from the Ministry of Road Transport and Highways. And therefore, we have no hesitation in passing a similar order in the present case. Stop. It is no doubt true that there may be an arbitration appeal pending for adjudication. But the arbitration is between the signatories to the agreement. And for that purpose, the affected landowners, due to the construction of the road, cannot be made to wait for the outcome of such proceeding. What observation do you want, Mr. Sanktam?
Your Lordships, may I pray that 3 letters being written by the state respondents may also be reflected in the judgment.
This court has also been informed that the state government, pursuant to the sanction made by the Ministry of Road Transport and Highways, with a condition that the amount so sanctioned should be recovered from the agency charges of the state PWD. Please read the sentence again. Has been replied to by the state government by writing as many as 3 communications. What did you write?
Your Lordships, one by the Commissioner Secretary to the Government of Nagaland, Works and Housing Department. Second, by the Chief Secretary of the State. Third, by the Deputy Chief Minister, Minister in charge of the PWD, National Highways.
You have given us only one, isn't it?
3 letters.
Just give us the date. What is the date?
Your Lordships, by the Commissioner Secretary to the Government of Nagaland, Works and Housing Department, by letter dated 23rd November 2023.
23rd November.
23rd November 2023.
Where's that 23rd November?
At the top on the right side.
Okay, 23rd. Then next.
Second.
Just give me the date. 21.
21 December 2023.
And the next is January 12th.
January 12th January 2024. Your Lordships. Below the TO letter. 12th January 12th 2024.
Let me just add something to this. My concern as the PIL petitioner. Basing on this particular dispute that is going on, again, the disbursement to the common public has been halted. Because this is particularly relating to a recovery. How later on the Union of India is going to recover. So that comes later. But on that basis, as Lordship has already come to know, we are saying that the contemplation also pending. They are not paying the money to the concerned public at large, even though judgments are there. So taking this as a ploy or as a pretext that we have a dispute among us, the public should not be kept left high and dry. Because this is ultimately a matter of recovery. How are we going to recover?
That's right.
That also has to be
Only thing is that I'm just reflecting what is submitting. That's all. Okay.
Otherwise, then they will take this as a pretext, saying that
Your
this is
Lordship,
still going on, so the money cannot be paid.
we are ready to pay.
Then
We are
let
ready
it
to
be paid.
release. However,
Let it be paid.
because of this particular conditions.
Yes, but this will come later on. This is subsequent. After the payment is made, how the recovery takes place.
Money has come already.
Yes,
Yes, it has reached the
sanction, but
No, it has
because of
reached
this
the-
condition, Your Lordship, for PIL 9.
No, sanction, the money has come.
Yes, Lordship.
Yes.
I have.
Once the payment is done, recovery will be imposed from the state.
So
That
that
is
is
the
a
main
subsequent
problem.
aspect. But on that, because of that, they are stopping the money. So already 2 checks have come on 4/1/2024 for an amount of 41 crores. And then on 12/1/2024, 19 crores 94 lakhs. I apologize, I do not have the printouts, but
No.
it is there.
Recovery part, that is for you and the ministry to take it up.
Exactly.
Okay.
Nothing was reflected in the judgment and order,
Yeah.
which was passed on 30th January 2023. Your Lordship. We, as a state being the supervisory agent, we have no authority, we
Okay.
have no fund. to
The
make
three
the payment
letters,
for damage compensation.
They're taking this as a pretext to stop the payment now, the state.
the three letters written by the state government is dated 23/11/2023 by the Commissioner and Secretary to the Government of Nagaland to the Secretary, Ministry of Road Transport and Highways, letter dated 21/12/2023 by the Chief Secretary to the Government of Nagaland to the Secretary to the Government of India, Ministry of Road Transport and Highways, and
January 12, 2024.
and the third is a letter dated, DO letter dated 12/1/2024, written by the Deputy Chief Minister, Nagaland,
To the Honorable
to the
Union Minister.
Honorable Union Minister, Ministry of Road Transport and Highways, New Delhi. To stop the learned additional AG submits that nothing was reflected in the judgment and order of this court in PIL 9 of 2019. And therefore, the Ministry of Road Transport and Highways could not have imposed such a condition in the sanction order. Next para. Be it stated herein that the question of recovery is between the state government and the Ministry of Road Transport and Highways, and the same cannot be an impediment for disbursement of the assessed compensation amount to the landowners concerned. To stop. Therefore, the respondent authorities, both in the state government as well as in the Ministry of Road Transport and Highways, shall process the matter of according sanction and payment of the same to the landowners concerned. Without any delay. And without waiting for the resolvement of their differences insofar as the recovery of the sanction amount is concerned. Full stop. Next para in the result, the writ petition is this, the
Yeah.
writ petition, the PIL is disposed of with a direction to the state government to initiate a proposal. What was the language given here?
Yeah, last page.
Second last page.
Running page 9.
To submit a proposal along with the assessment made to the Ministry of Road Transport and Highways within a period of
6 months.
no. To initiate within a period of 4 weeks from today
2 months, Your Lordship. 2 months.
to initiate.
2
State
months.
is getting the money. Why is it delaying? I don't understand. You should have
2
said
months
tomorrow.
time.
No, you're supposed to just to forward like that only. Why 2 months for that?
Necessary.
No, if you take 2 months, they will take another 6 months to sanction.
Right.
In this judgment, it says 6 months entirely. It has not divided who will take this much amount. We intend to divide.
1 month, I think, would be appropriate. 1 month.
1
is
month.
Within a month from the date of receipt of a certified copy of this order. And the Ministry of Road Transport and Highways, upon receipt of the proposal, shall, within the next period of 2 months, accord proper sanction and communicate the same to the state government. Okay, 3 months, 3 months, 3 months. 3 months. No, 3 months, not beyond that, 3 months.
3 months.
And the and the amount so sanctioned and submitted to the state government shall be disbursed to the landowners concerned through the Deputy Commissioner of / District Collector without delay by observing necessary formalities as may be required. Writ petition, the PL accordingly stands disposed of. Anything to be added?
That without delay can be circumscribed by a period of time. That last Lordship has
Ah.
said the disbursement without delay.
Ah.
Now again, there's not been circumscribed by a outer limit. That delay.
Delay, you cut that, okay? Last part, I said delay.
That also some period. will be-
No, you write immediately.
Obliged, Your Lordship.
Much.
For admission, item number 15.
Yes.
The present writ petition is a habeas corpus petition.
Okay.
Challenging the detention order dated 31/2022.
Okay. Pleadings have been exchanged.
The detention order is at page number 49.
Pleadings have been exchanged.
Just pleading has been completed. The union as well as the state government, they filed
Hmm.
this affidavit.
Where's the impugned order?
The detention order is at page number 49. The detention order was passed by the Commissioner of Police and District Magistrate Mapunahan. So I submit forward the subsection 3 of section 3 of the MCA.
Page 49.
Page 49.
49 is a letter.
I'm relying on the amended petition. During the pendency of the repetition, the state government has issued a confirmation order. So we have filed an amended.
Okay, amended this. How much you said? Page
49.
49. Yes.
This was issued on 31st August 2023. The detention order was approved by the state government.
Detention order is under subsection 3, section 3 of
Yes, yeah.
what does the provision say?
The provision
Detention can be done under subsection 2 of section 3.
subsection 2 of 3 that can be exercised by the state government.
Then what is subsection 3? Any difference between 2 and 3?
Initially, under subsection 2 of 3, that has to be issued by the district magistrate or the commissioner of police.
Subsection 3.
And that is subject to approval by the state government. Under subsection 2.
Under subsection 2, state is to approve.
State has to approve.
And for how long can you be detained?
The petition will pass by the detaining authority that is valid for 12 days. Within the period of 12 days, it has to be approved by the state government.
And once it's approved by the state government, a fresh order has to be passed.
Now, again, that is subject to confirmation on the advice of the advisory board.
Subsection 3 does not provide period.
Under the proviso, the initial detention order has to be issued for a period of 3 months. And that has to be given, that can be extended within for another 3 months.
No, that is under subsection 3.
After the exercise of subsection.
Okay. So initially you said 12 days.
Yes, sir.
Where did you get that 12 days?
Subsection 4. Where any order is made under this section by an officer mentioned in subsection 3. He shall forthwith report the fact to the state government in which subordinate, together with the grounds on which the order has been made, in such other particulars as have a bearing on the matter. And no such order, should the first division, shall remain in force for more than 12 days after the making period, unless in the meantime it has been approved by the state government.
Supposing it is not approved by the state government,
That's very good.
it has to be revoked. Person has to be released. In your case, it was approved. First, you were given under subsection 3, then subsection 2.
In the subsection 2, it has been approved.
And this is the first order, 31st August.
31st August.
First order. Then the confirmation order came.
Later on.
Confirmation is order is under subsection 2.
Confirmation order, Lordship, confirmation order, it has to come subsequent to the advice of the state advisory committee, advisory board.
Under what provision?
Under section, 10, 10, Lordship. No, under under section 11, the state advisory board, they have to, the
12.
Yes, Lordship, the state,
12.
the advisory board will consider under section 11. On the basis of the advice given by the advisory board,
11 is procedure of the advisory board. 12 is the action upon the report of the advisory board. And any duration prescribed?
the advisory board,
As it thinks fit.
under, section 11, it says that within 7 weeks, the advisory board has to give its report, has to submit its report.
No, once the report is given, then the advisory board recommends, accepts the report and it recommends. How long can a person be kept in custody? I mean, being detained?
Under section 3, the maximum period of detention will be 12 months.
1 year.
1 year from the date of detention.
And it cannot go beyond 1 year? Or what?
Provision to section 13 says that provided that nothing contained in this section shall affect the power of the whole government to revoke or modify the decision order. Section 13 says only that the maximum period for which any person gain a person's of any division order, which has been confirmed under section 12, shall be 12 months of the
So maximum is 12 months. So even after the advisory board has accepted, it can still be modified by the appropriate government by making it short or revoke the detention. So first is 12 days, then the confirmation from the state government. No, from then it has to go to the government
It needs the government for approval.
for approval. Thereafter,
Thereafter, it will be placed before the advisory board.
advisory board within a period of
With the period of,
6 weeks. 3 weeks.
yes, within 3 weeks. Under section 10.
Within 3 weeks.
3 weeks.
Then advisory board says yes, then one can be go up to 12 months. Then that can be revoked or can be modified by the appropriate government, if so required. You were in since August, 31st August.
31st of August.
Maximum period will be till August this year. So now you are praying for this habeas corpus, with this habeas corpus to be released.
The person made petition has been filed by the wife of the detainee.
Correct, correct.
We need to look at the facts of this.
You were arrested on 31st August
Yes, Lordship.
itself. And the order was passed on the same day.
No. Leaving the custody. No, Lordship, even July.
From where are you saying that?
The fire is at page number 60.
60.
16.
16. Please continue.
The rest of the beginning, I of the case. So the I of the case at the summary is the report. The report is at page number 30. This is the detailed report of the sponsoring authority. The sponsoring authority is the Deputy Commissioner of Police. Mapo. He submitted a proposal to the ticketing authority. The sponsoring authority submitted its report on 24 July 2023. That is page number 39. And on the basis of the proposal submitted by the sponsoring authority, the implementation was issued by the ticketing authority. This is the commissioner.
No, let us start from the beginning again. The Suamotu FIR was filed before the Savima police station. That was on 10th of July.
10th of July.
Then you were arrested next day.
On the next day.
Next day.
Submitted its report.
11th July, you were arrested. How many persons arrested? One.
No, in this connected case, six persons were arrested in the same case.
6 persons arrested. You are one of them.
I was one of them.
Others have not come.
Others are also come.
They have also come. Where is the case?
I think 17 lots, same case.
How many of them are there? 70.
I think 17 only one.
So only two are there before this court.
Others, they have taken a date to me.
Huh?
They have taken a date for next week. So they have received the activity this month.
Okay. So is it not advisable to take up all these matters together?
These two matters can be taken up together.
On the writ petition, they are filed on separate grounds.
Separate grounds. Your roles are different. Alleged role.
These rules are, but
It all pertains to recovery of 1,500 rounds of ammunition. And thereafter another 1,000. Total 2,500. Is that correct?
Nothing was seized from us. $500, 7.60 PNM,
Any Caesar memo? So how do we depend upon the FIR only then? Hmm.
Report submitted by the IU, here's the information about the sea surveys.
So the advisory board has given its recommendation.
Yes, sir.
What does it say? Where?
Should the advisory board give its opinion that it is a fake case to detain the detainee under the NSC?
Where?
The report is not with you. The report has been called for in the report of the advisory board.
So how are you detained as on today? On what basis?
On the basis of the detention order.
No, no, on the on the basis of Annexure D.
Annexure 2 years.
Annexure D is only for 12 days, isn't it?
If this is approved by the state government.
This has been approved. Where is the approval?
From the page number 55. It was approved on 11 September 2023.
So state government has given approval.
State government has given some. The detainee is submitted a representation.
No, see, this approval also says that with effect from detention till 30th of November 2023. Thereafter, what happened?
Even after the state government has issued a confirmation order.
Where is that?
Page number 66. On the basis of the advice given by the advisory board, the confirmation order was issued on 17 November 2023 for a period of 3 months.
For another period of 3 months.
One period of 3 months.
With effect from 1st of December.
Yes, Mr. Till 20th of February 2024.
But you said that advisory board has not recommended.
No, advisory board has given its opinion that the person detained is fit to be detained under this.
Advisory board is against you.
Against me.
But sometime back you were saying that it was saying that you were saying the other way around. Any recommendation? Mr. Tiva, what does it say? Fit to be detained? Okay. Fit to be detained?
Yes, ma'am.
Okay. Then it's okay. But I thought you said not fit to be detained.
Fit to be detained.
Fit to be detained, okay. So that's why you're on detention till today. Arrested, then approval was there, then confirmation order is there. Advisory board has passed any order. Advisory board has passed the order. Is it available in your writ petition? Confidential. So what do you have in your writ petition? Only the confirmation order?
Yes, sir. The last is the confirmation order.
Confirmation order is on the basis of the advisory board approval. Now, if you go by the act, The advisory board is not required to give any opinion or any view regarding how long you should be there in detention.
Only opinion.
The appropriate government may confirm detention order and continue the detention period for such period as it thinks fit.
Should we see section 11 clause 1? Clause 2. Section 11 clause 2.
Yes.
The report of the advisory board shall specify in a separate part here the opinion of the advisory board as to whether or not there is sufficient cause for the detention of the person. So instead of this power, they have given its opinion against it.
So that is the case.
Yes, Mr. President. Now,
You are arrested, later on government approval is there, confirmed, advisory board said he should be detained. Then they pass the confirmation order and you are to be in detention till February 28, 2024. So what is wrong in this?
let us focus on petition ownership as you will see. It's a curtailment of the personal labor. Whether the procedure, prescribed procedure, that has been followed, that has been in the present case. I'm not challenging the detention order on several grounds, but one of the main grounds, which has come after the receipt of the state government, is that it is a several law that when the subjective satisfaction of the detaining authority is under challenge, the detaining authority has to file the subjective satisfaction of the detaining authority cannot be substituted by another officer. This is a civil law. In the present case, in the present petition, I'm challenging or alleging the action of the detaining authority. However, the affidavit in the present petition has been filed by the Principal Secretary Home Department on behalf of the detaining authority. That is also one of the problems which I think.
Who should file according to you?
According to me, it is the Commissioner of Police, Timapur. Since he is the detaining authority, he should file his affidavit justifying his reason, justifying his action.
Commissioner of Police was the initial authority
He's a
who detained you. Who detained you?
So his action is under challenge.
Then he sought the approval of the government. Government said yes. Then you went on detention again. Then thereafter, the matter was referred to the advisory committee, advisory board. Advisory board says detention is necessary. So everyone is satisfied. So why do you say that it is the Commissioner of Police alone who should have filed the affidavit?
Commissioner of Police. He's a detaining authority. He should file a separate affidavit justifying his mind. Justifying his action. But in the present case, the Principal Secretary to the Home Government or Home Department is filed an affidavit on behalf of the detaining authority. Worship to the readings in my read petition, where I have alleged the action of the detaining authority. Question will come to page number 10, para 13 in my read petition.
Just a minute. What authority do you have regarding that? It is the only subjective satisfaction of the detaining authority that he alone is to file the affidavit.
I'm relying on the judgment by the division bench of this court. 1998 column 4 GLD.
Page.
Page 40.
Para.
Para itu. Yeah,
Yes. Question. Can you go to-
here is yet another clause raised by the petitioner which relates to no supply of basic text to users, considering the grounds of detention by the beginning of the executing modified to no application of money to him in challenging his subjective satisfaction. The detaining authority has not filed any affidavit. The affidavit is filed by the successor in office. Ordinarily, the affidavit of opposition must come from the detaining authority. More so, in a case where modified is alleged in subjective satisfaction, challenge as in the instance. There is not even a whisper as to why the detaining authority who passed the Indian order election would not file an affidavit. Assuming he was transferred, yet he was pretty much available for filing. The affidavit filed by the district magistrate cannot see anything about the subjective satisfaction arise at the 10 district magistrate who passed the Indian order on 5/4/1997. Now let us examine the affidavit as shown and filed by citizens. Appended to read us. When I come to the last paragraph. How can he see upon the subjective satisfaction of someone else? Here is a glaring discrepancy. The Indian order of detention speaks of the activities that are prejudicial to the maintenance of public order, whereas the ground of detention refers to security of state and maintenance of public order. But the order does not refer to security of state, but it would only be explained by the authority who passed the detention order. It is significant to note that the successor in office is what the district magistrate who passed the detention order does not even claim is claimed by the successor in office. As quoted above, is speak about the satisfaction of the detaining authority. The Indian order as quoted above merely states where it has been made to appear to me. There is not the remotest suggestion that the 10 district magistrate was satisfied about the necessity of passing the detention order. The order does not anywhere see that the detaining authority was satisfied on the basis of materials placed before him that the detention order should be passed. It was a compulsive necessity. This cannot be allowed to be substituted by proxy. The subjective satisfaction of so cannot be approved by the affidavit of so. More so, in face, the discrepant nature of the Indian order, which has been passed on mere appearance and not satisfaction, the order is liable to be set aside on this ground as well. The remaining paragraphs is regards to the no supply claims. The same judgment has been referred in a subsequent judgment by the Supreme Court of this report.
But see, how do you apply this to your case?
Yes, Mr.
No, before you close that book, please come back to paragraph 8. There's one sentence very important. Paragraph 8. On the ninth paragraph, ninth line, I mean, ninth line of paragraph 8. Ordinarily, the affidavit in opposition must come from the detaining authority. More so, in a case where malified is alleged and subjective satisfaction challenged, as in the instant case. These are the conditions, these are the parameters.
That is a parameter. That's
my lordship, in the present petition,
It doesn't say that in all cases, one has to file affidavit. It says ordinarily, affidavit should come from the detaining authority, especially when the detainee says that this is malified.
At the present petition, at paragraph 13, and as well as in the ground of, in the grounds, you have specifically alleged about the subjective satisfaction of the detaining of
Paragraph?
paragraph 13. Page 10.
No, you may say many things, but you must mean it also. It must have some force. Paragraph
Paragraph 13, you see,
paragraph 13.
page 10.
Yes,
Here, you see,
yes.
that the sponsoring authority in its report dated 27/4/2023 had stated that the subject is likely to move for bail and possibility of being enlarging on bail. The detainee has not moved any court seeking for bail. However, from the grounds of petition, it can be ascertained that respondent number 4, so that is a detaining officer, passed the implementation order dated 31/8/2023 based on the report submitted by the sponsoring authority.
Sponsoring authority means?
Sponsoring authority is the Deputy Commissioner of Police.
Deputy Commissioner submitted report.
Deputy Commissioner of Police submitted the report. The detaining officer has taken into consideration of the report in first detention. Receipt that can be sent from the schedule annexed with the grounds of detention.
Where?
The grounds of detention which was been served to the detainee along with the detention orders at page number 51.
This is by the Commissioner of Police.
Commissioner of Police.
No,
Detaining officer.
but this statement of yours says that
In the schedule, there is a page number 52.
no, what about the sponsoring authority? Who has sponsored? Your paragraph 13 statement says that based on the report submitted by the sponsoring authority.
The page number 39 is a proposal submitted by the sponsoring authority.
39. Petitioner's name, what is his name?
The present detainee.
I mean detained person.
Lanu Sanan.
Sorry?
Lanu Sanan. In the speak of the present detainee is a page
Lanu
number-
Sanan.
Yes, sir. Page number 44. Accused number 5.
So what has this deputy commissioner written to?
Yes, sir. It should become page number 44.
Uh-huh.
Page 44.
Yeah.
Accused number 5. Yeah,
Oh.
the report submitted by the sponsoring authority.
So who should be filing the affidavit? The sponsoring authority or the
Detaining authority.
detaining authority?
When is the subjective satisfaction is alleged in the is alleged. He has to file his affidavit justifying his action.
See, the sponsoring authority has written on 24th of July. But Suomoto FIR was filed on 10th of July. It is not on the basis of the sponsoring authority that FIR was filed.
No. On the basis of the FIR,
Hmm.
Worship, an inquiry was conducted by the IU of the case.
Okay.
On the basis of the report submitted by the IU,
Ah.
again the sponsoring authority is submitted this proposal to the detaining authority.
No, inquiring authority, on the basis of the FIR, inquiry was done. And that inquiry was given to whom? To the deputy commissioner.
Inquiry was submitted to the detaining authority, to the deputy commissioner of police.
Okay. Deputy commissioner of police, all right.
That is the detaining authority.
Mhm.
Now, on the basis of this, the sponsoring authority has submitted its proposal, requesting to detain the person detained.
No, deputy commissioner of police is the detaining authority.
Is the detaining authority.
And who is the sponsoring authority?
The
Who is the sponsoring authority?
deputy commissioner of police.
He is also sponsoring and is also detaining authority.
No.
Hmm?
The deputy commissioner is, yeah.
Detaining authority is the commissioner of police.
Commissioner of police.
Okay. Okay, then it's okay. Deputy commissioner is the sponsoring, commissioner of police is the detaining authority. And these are all based on the, first of all, the Suomoto FIR investigation. Deputy commissioner says that there is material. Commissioner says, okay, detain. And now you say that commissioner of police should have objective, subjective satisfaction that he is to be.
Since the commissioner of police,
Hmm.
since he passed the petition,
Hmm.
now in the present rate petition, we are alleging the subjective satisfaction of by him when issuing the petition. We should file that justifying his action.
The impugn order says in paragraph second, I, Commissioner of Police so-and-so, is satisfied with the view to prevent above said accused person from acting in the manner prejudicial or security state.
Worship, this is based on the schedule. Worship, we come to the schedule.
Hmm. Schedule
52.
52.
Yes, Worship. This schedule, it was served to the detainee along with the detention order.
Schedule is prepared by whom?
Schedule is prepared by the detaining authority.
Commissioner of Police.
Commissioner of police.
So this itself will be the subjective satisfaction.
Exactly. I'm questioning this. Without any materials to substantiate the proposal submitted by the sponsoring authority, he has accepted. That is what I'm alleging in the present case.
Okay.
Should may come, this is page number 52, those are the facts.
Hmm.
So the conclusion arrived by the detaining authority is at page number 52.
Hmm.
May I read?
Yes.
The subject, that is the detainee, with his full conscience of mind, indulged in dealing of illegal ammunition supplied to his friend, who is an active member of factional group, for his personal monetary gain by knowing the impact of prohibited ammunition. Number 3, that as per request made available by the sponsoring authority. That's what I'm.
Hmm.
The subject was arrested for dealing in illegal arms and ammunition and possession of the same, which is a threat to public security and detrimental to the tranquility and maintenance of law and order in the state. Number 4, that the subject so and so is presently under judicial custody at Central Jail Dimapur. If he is not detained, he is likely to indulge in similar prejudicial activities unless an effective alternative measure is called for. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be put under National Security Act 1890. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state of Nagaland and maintenance of public order, the undersigned has ordered the detention of the subject under the said act.
So what is wrong in that?
Yes, sir. Question may again come to the page number 44. These are report of the sponsoring authority. Yes, taken into consideration the report submitted by the sponsoring authority. I'm making in respect of the present beginning.
Yes.
On interrogation, he stated that he was born and brought up from the Gauhati village, Fort Mat. He is calling from Mission School, Timopol, and later graduated from Kilan Kapa Mineral College, Timopol, in the year 1980. After completing his studies, he engaged himself as a government medicine supplier since 2008. He is married and has one son and his wife working in medical department, in the first week of June 2022. His childhood friend, namely Timbang Shimra, this four, visited his place and told him that he needed some ammunition and requested him to arrange some ammunition if he had some contact with friends. So he told him he would ask around. Then later on, he contacted his friend Michael Rita, age 6, whom he had known as for the past 7-8 years. Now, through Yamaha RD 350 Bike Club, who is residing at Fort Mile, Jumurjima. Michael, age 5, is a police at the rank of inspector and asked him whether he can arrange some ammunition for him. And Michael came to his house in the evening, so he asked whether he can arrange some ammunition, at which Michael told him that he would send. After that, at around first week of July, Michael came to his house and told him there is possible. He could not ascertain the date since Michael is a frequent visitor. After which between 1 to 4 of July 2023, he went to Michael's house and Michael told him that he can arrange 150 nodes of 7.62 in 51 mm and 1,000 nodes of 5.56 into 45 mm. But the cost of the ammunition will be rupees 150 for 7.62 in 51 mm per round and rupees 200 for 5.56 into 45 mm per round. Total rupees 4,25,000. He pulled up Tingbam, age 4, and informed him that he can be arranged. After which, around 3rd to 5th of July, age 6, Michael came by auto and give him the ammunition which was packed in 2 rice bags. After that, he informed age 4 Tingbam that 1,500 nodes of 7.62 and 51 mm and 1,000 nodes of 5.56 in 45 mm has been arranged. On informing accused for Timbang, he came to Fort Mile on 8/7/2023 and both went up at Fort Mile near NEZCC and handed over the ammunition to him without counting it with an amount of rupees 6,50,000, rupees 200 per 7.62 and rupees 3,350 per 5.56 into 45 mm ammunition at around 13 hours at 14 hours. Further, he stated that payment was made through cash on Monday, that is 10/7/2023 at around 12 hours. His friend accused for Timbang called him up and put up with Marwaripati Timopol town and Timbang handed over rupees 6,50,000 to him at around 2:30 hours. The next day, that is 11/7/23, he went to his from Michael house and handed over rupees 4.25 lakhs to him at around 8 hours to 9 hours, and in return, Michael gave him rupees 30,000. He also said that he took a commission of rupees 2.2 lakhs 25,000 from the ammunition which he sold it to a disport income and handed over rupees 4 lakhs 25,000 to Michael, and again Michael gave him rupees 3,000 for miscellaneous expenses. The subject with his whole conscious of mind indulged in dealing of ammunition supplied to his friend, who is an active member of factional group for his personal gain by knowing the impact of prohibited ammunition. These are facts reported in respect of the present beginning. The grounds proposed by the sponsoring authority is at page number 48. Page number 40. grounds on which the arrested person may be detained under NC. This is not only in respect of the present detainee, but in respect of all the accused in the connection with us. Number one, the subject are presently in judicial custody in connection with Surima D's case number so and so, who were forwarded from police custody with a prayer for 15 days to serve remand in the interest of justice and to avoid the ongoing investigation. Their presence in public places engaging in the supply, heating of restricted ammunition, hinting that there are malified intention of indulging in wanton criminal activity, which is highly detrimental to the maintenance of peace in public safety. The subject are likely to move for guilt. The subject are likely to move for guilt, thus increasing the possibility of them enlarging on guilt, in the possibility of the subjects indulging in criminal activities. Criminal activities is real if allowed to go freely. Thus, every possibility of the subject indulging in similar procedural activity, which will be injurious to maintenance of public order and have the potential to affect the peaceful environment and normalcy of life. Based on the above facts and circumstantial evidences established during investigation upon the arrested persons, namely Elizabeth Zingai, that is Sophia, 42 years, accused 2 Rashul Lingbai, 38 years, accused 3 Tingbam Shimra, 45 years, accused 4 Lanusanan Poner, 45 years, and accused 5 Michael Yandan, 41 years, have committed offense of brief nature, which can have an adverse impact on the security and integrity of the state. Conscious and deliberate involvement in the supply of private ammunition in large quantities is a threat to national security and maintenance of law and order. Therefore, it is paid to the concerned authority to kindly allow for detention under Section 3(1) and 2 of the National Security Act for the accused 1, 2, 4, 5, and 6.
Petitioner is accused number
Accused number
5.
5. The present detainee. Being filed by the wife of the detainee. Ground number 3. The question is, the sponsoring authority has given this proposal saying that the detainees are likely to move the field. However, till the time of passing the detention order, no bail application has been filed by the present detainee. In the report submitted by the sponsoring authority, this has been taken into consideration and accepted by the detaining authority.
Arrest was on
Arrest was on
11.
11 July 2022.
And this ground made on 24th.
24/17.
So for 13 days, almost 2 weeks, no bail application was filed. So this apprehension that he might file bail.
I may file bail and I might be released only. That was a report given by the sponsoring authority. That was taken into consideration and accepted by the detaining authority, and the present detention order was passed. So when such an allegation is alleged in the present petition, this action has to be justified by himself, but not by a proxy officer.
That is one ground.
That's one of the main.
You have other grounds also?
I have other grounds also. In the habeas corpus petition, one ground is sufficient to quash the entire petition. Also, we can see the affidavit filed by the Special Secretary to the Home. The Union of India, as well as the state government, they filed their respective affidavit.
See, today I think we're out of time. We'll have to hear the other side also.
It's an admitted fact. If they cannot deny that the affidavit on behalf of the detaining authority was filed by the Home Commission or by the Special Secretary, then the waiting was. In the paragraph number 1 is specifically stated that now I am presently serving as Personal Secretary under the Department of Home, Government of Malaysia. When I have received a copy of the writ petition filed by the petition, when I have gone through the same, when I have understood the contents nature, I am also familiar with the facts and circumstances of the present case, and being duly authorized, I am competent to swear the affidavit on behalf of the state respondent. And in the affidavit in opposition filed for and on behalf of state respondent 1, 2, 3, and 4. The Commissioner of Police in the district magistrate is the related as a respondent. So the Personal Secretary of Home is sworn an affidavit on behalf of the detaining. This has been totally non-application of mine on the part of the respondent where the personal liberty of the person detained has been protected. So we kindly see the paragraph 8, the statement made by the Principal Secretary. As if he has issued a detention order, is justifying the action of the detaining authority. Paragraph 8. May I read, Worship? But regardless of made in paragraph 14E to H in 16 of the writ petitions are the grounds of submission of the petitioners are vehemently denied. The answering deponent humbly begged to state that the deponent was well aware that the detainee was in judicial custody and fully satisfied the material briefs on the courts. In of the third application of mine, the detention order was passed directing detained under section so. The detention order, initial detention order was issued under subsection 3 of section 3 of the NSCA, not under section 120 EIPC so. This affidavit was also filed without non-application of mine. Why is one statement? When the personal liberty of an individual has been curtailed, we should kindly see the action of the state respondent. He's saying that the detention order was issued under section 120P IBC, with 25I, 1E, and 1E arms act.
And detainee was in judicial custody also.
He's saying that yes, he was in judicial custody. See the subsequent paragraphs. The following grounds of detention were examined and considered while passing the detention order. That is Swinson. He has not passed the detention order. The detention order was passed by the Commissioner of Police. He is swearing an affidavit as if he has issued the detention order. So on this front alone, the entire proceedings has been evaluated. The president petition may be allowed in this front alone.
Yes, the affidavit, in fact, he says that he has filed on behalf of all the respondents. So he speaks on behalf of everyone.
He speaks on behalf of the judgment officer, which is not permitted by the judgment passed by the in the subjective satisfaction of the judging office alleged, it has to be explained by the judging authority. It cannot be substituted by a proxy. That is the settled notion. In the present case, the present secretary is justifying the action of the judging officer. The similar steps has been adopted in the relevant film case. Similar steps. Totally not objection. The judgment passing the present case recovered in the French case also. The judgment passed by the Korean page in the year 1999. This has been referred in the subsequent judgment also. Here is
Okay.
more clear.
See, Mr. Lima,
Yes.
we're thinking that we'll continue with this matter on some other day. Because we have to hear the other side also. You can have it on Monday.
Monday is here in the page worship only a second Wednesday. Not examination, but it's up to your lordship. Lordship can
Yes,
consider special
Wednesdays, there's basically division bench days, but one day is not sufficient. So that's why if you can have it some other day,
Monday, lordship.
Wednesday again will be too far away.
Next Wednesday again it will be overcrowded.
May I
Exactly.
please, Your Lordship?
Yes.
My lord, in this case, there are 6 accused and 5 of them has filed writ before this court. And out of 5, 4 I have filed affidavit and 1 I yet to file. So today, 5 of them has listed, but 2 has been adjourned to list after 1 week. So that the matter can be taken up later now. All the matters. Yes. Wednesday, my lord.
Time constraint is there Wednesday.
If a person with petition, if in the other with petition also, if they committed the same mistake.
Even if you don't file affidavit, I think we can take your arguments because I think more or less it will be the same story.
Yes, ma'am.
Because all the materials are already here.
Yes, ma'am.
So let us try on Monday.
Okay.
He's right, as paid for by the parties, list the matter again on Monday. That is
Along with my friend case also.
12 February 2020. Similar order in item 17, yes.
For orders, item number 23.
I'm sorry, Lordship. Lordship, I'm sorry, on Monday I have a case within the district court.
Tuesday? Tuesday?
Yes.
Make it Tuesday, huh? 13. 13th of February.
Otherwise, Lordship, I have nothing much to say also. If my presence may be shown, then that.
Then we can take on Monday.
If my presence is shown, then I have nothing to say.
They have not filed the affidavit also.
You have not filed affidavit?
No, I filed in.
You
That will cover all the. One affidavit will cover.
Just one thing, if the ground which have reached just now, if I cannot succeed in that ground, then I have to take another ground based on the affidavit filed by the CGC. On the ground of the delay in disposal of problems.
So let him be here. He'll be here on Tuesday.
On Tuesday, Lord.
Tuesday. And be ready with the authorities you want to rely upon. Give that in advance to the bench so that we can get the books also. All right. Respondent number 5 not served.
Yes, as per the office note dated 5/02/2024.
Yes.
Written service report is still awaited, Your Lordship.
Well, but this was served in December.
Yes, Lordship.
1 month has elapsed.
Item number.
Yes, Lordship.
Who is respondent number 5?
Private respondent. Your Lordship. The Secretary Registrar, Board of Homeopathic Medicine, Nagaland.
Is respondent number 5 necessary party?
Yes, Lordship. Necessary party, Lordship.
But where is the office located? Board of Homeopathic. How will the postman look out for this address? Unless you give the locality, house number or like that.
Lordship, in that case, if I may be allowed to take fresh steps, Lordship, through dusty service.
Okay. Office note indicates that neither unserved notice nor ID card has returned back from the respondent number 5. Stop as paid for by the learned counsel for the appellant. Let notice be effected upon the respondent number 5 by way of dusty within 10 days from today. The appellant shall thereafter file an affidavit indicating dusty notice served. List again after 2 weeks.
2 weeks, Lordship.
3 weeks.
Lordship, I'm sorry for the interruption. Lordship, in item 16 and 17, I have received the affidavit in the possession of the union.
Yes.
However, in the affidavit, it is written as to Honorable Justice Mr. Lanasangam Jamir. So that is why the filing is refusing to accept this affidavit.
Okay.
Just because of this. So if my lordship may give the permission to file it as it is, as I have received. In the case that was taken up today.
Can't you rectify that?
Then I have to send it back to the.
No, only because of that cause title. Why do you have to send it back?
Yes, that's why I may be allowed to file this as I have received from the union.
No,
on the ministry.
you rectify it at this stage. Is it
Actually, because it's already signed and
notarized?
Yes, it's already notarized.
No, these things actually, I don't think this is crucial.
Yes, it's not crucial, but
In any.
But the filing register, they are refusing to accept this.
When was it notarized? December. December.
Yes, I have received a copy just last week. I supposed.
No, the thing is that can you not rectify this by writing the current Chief Justice and give your signature?
The filing registry, there is an instruction that there should be no
Overwriting.
No overwriting.
Okay.
So if this can be accepted as it is, then
Okay, I'll speak to the registry. This is item
16.
What order did I pass? 16. What did I say? 16?
Oh, no. That is item 17, Lordship. Item 16 is it.
16 and 17, isn't
16
it?
and 17, Lordship.
What order was passed?
In the to accept the affidavit as was received from the ministry.
No, no, we have already passed an order. What was the order passed by us?
17.
Okay. You had sought adjournment, 16 and 17?
No, Lordship.
Who had sought adjournment?
Lordship, if my Lordship on 14/12/2023, that is in other case. This honorable court has stated that the Lord Council for the respondent shall ensure filing of the
What order did we pass? This is the thing I'm asking. Just read the order, item 17. Continue, okay. Mr. Gauhati, Lanet CGC, appearing for the Respondent Union of India, submits that he has received the vetted counter affidavit of the Union of India, but is unable to file the same since the cause title of the affidavit mentions the name of Justice L.S. Jamir, Acting Chief Justice, instead of the present Chief Justice. To stop on perusing the affidavit shown to this court by Mr. Senti Younger. Oh, sorry, Yangarwati. It is seen that the affidavit was already sworn and notarized on, what is the date?
Will be the last page, Your Lordship. Last second page.
29/12/2023. Stop. Therefore, registry shall permit the learned CGC to file the said affidavit. Then the first part, you put in the last part, okay? As paid for by the parties, this again on Tuesday next. Okay. This takes care of item
17.
17.
Yes. I have the same problem in item 16 also.
But 16, what order was passed?
Seeking 1 week time. Adjourn for 1 week. That was
Okay.
adjourned for 1 week.
So can we have a similar order in this?
Yes, Your Lordship.
Earlier
So-
order you cancel, okay? I think we must have signed it somewhere. 16.
So even without the order, if Your Lordship gave a direction, oral direction, then I can find along with. Even with.
All right. No, 16, let it be a same order.
Yes.
Let it be a same. That's all.
That's